Let's come to order and go on the record, please. I'm Charlotte Mitchell, Chair of the North Carolina Utilities Commission, and with me this morning are Commissioners Duffley, Hughes, McKissick, Kimwright, Brawley, and Tucker. I now call for hearing docket number G9 sub 837 in the matter of application of Piedmont Natural Gas Company Incorporated for an adjustment of rates, charges, and tariffs applicable to service in North Carolina, continuation of its IMR mechanism, adoption of new depreciation rates for its utility property, regulatory asset accounting treatment for certain operating expenses, and other relief. Before we proceed further, as is required by the State Government Ethics Act, I remind members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any member of the Commission has a known conflict with respect to matters coming before us in this proceeding. All right, the record will reflect that no conflicts have been identified, so we will proceed. On February 29th, 2024, as is required by Rule R117 sub A of the Rules and Regulations of the North Carolina Utilities Commission, Piedmont Natural Gas Company Incorporated, or Piedmont, filed a notification of intent to file a general rate case application. Thereafter, on April 1st, 2024, Piedmont filed its general rate case application with the Commission, in which it requests the authority to adjust and increase its rates and charges for natural gas service in North Carolina. Included with the application was the direct testimony and exhibits of witnesses supporting the application. In its application, Piedmont specifically requests an increase in and revisions to the base rates and charges for customers to account for changes in rate base, operating revenues, costs, and capital structure that have occurred since Piedmont's last general rate case proceeding in 2021. The increase requested by Piedmont would produce additional annual North Carolina retail revenues of approximately $149 million, which is an increase of approximately 11.7% over its current revenues. On April 22nd, 2024, the Commission issued an order establishing general rate case and suspending the proposed new rates for up to 270 days. On June 12th, 2024, the Commission issued an order scheduling hearings, establishing procedural and filing requirements, and requiring public notice. The order scheduled hearings for the purpose of receiving testimony from public witnesses in Wilmington, Charlotte, and High Point, as well as several hearings held remotely by way of WebEx. The scheduling order further scheduled a hearing for the purpose of receiving testimony and other evidence from the expert witnesses of the parties to commence on Tuesday, September 17th at 10 a.m. The public staff, which represents the using and consuming public, has been made a party to this proceeding in accordance with North Carolina General Statute Section 62-15 sub D. In addition to the public staff, the following parties have been allowed to intervene in this proceeding: Carolina Industrial Group for Fair Utility Rates 4, SIG for 4, Carolina Utility Customers Association Incorporated, or CUCA, and Nucor Steel Hertford, or Nucor. On August 13th, 2024, the public staff and CUCA filed testimony and exhibits of their witnesses. Neither SIG for 4 nor Nucor filed testimony in this proceeding. On August 28th, 2024, Piedmont filed the rebuttal testimony of its witnesses. And on September 10th, 2024, the public staff filed a notice of settlement and motion to extend certain procedural deadlines. On September 11th, 2024, the Commission issued an order continuing the expert witness hearing until today, September 18th, at this time. On September 13th, 2024, filed with the Commission was a stipulation of settlement as well as testimony supporting that settlement from the public staff witnesses and Piedmont witnesses. On motions of the parties, the Commission has, by orders, excused certain witnesses who pre-filed testimony from appearing at today's expert witness hearing. All right, that brings us to today. I will call on counsel to introduce themselves for purposes of the record, and we will begin with Piedmont.
Thank you, Madam Chair, members of the Commission. My name is Jim Jeffries. I'm with the law firm of McGuire Woods. I'm here on behalf of the applicant, Piedmont Natural Gas Company, today. With me at council table are Mr. Brian Hesselin, who's Deputy General Counsel of Duke Energy, and my partner, Mr. Brian Franklin, who's also with McGuire Woods.
Good morning, gentlemen. At this side of the room.
Morning, Commissioners. My name is Megan Yost. I'm with the public staff. Appearing with me this morning are Davia Newell and Gina Holt. We represent the using and consuming public.
Good morning, Ms. Yost.
Good morning, Chair Mitchell, Commissioners. Marcus Trathan with the law firm of Brooks Pierce, making an appearance for CUCA. And if I could, just with me is Kate Giddas from my firm. She's been helping me on some utilities matters, and you'll see her from time to time. Just wanted to introduce her to you.
All right, thank you. Good morning, Mr. Trathan.
Good morning, members of the Commission. My name is Ashley Stokeham with the law firm of Bailey and Dixon, LLP, appearing on behalf of SIG for 4.
All right, good morning, Ms. Stokeham. All right, before we get started, I will see if there are preliminary matters.
I think, and obviously it's at the chair's discretion how we handle this, but there's been a stipulation between 4 of the 5 parties to the docket, and in that stipulation, those parties, which are the Piedmont Public Staff, CUCA, and SIGFR 4, have agreed to the entry of the testimony of non-appearing witnesses into the record today and have waived cross-examination of all witnesses. It's my understanding that while Nucor is not a party to the settlement, that they have no objection to the settlement and have waived cross-examination of witnesses as well. So if the chair would entertain the motion at this time, the company would move for the admission of pre-filed testimony and exhibits of those witnesses that are not appearing today in the record.
All right, Mr. Jeffries, let's do this. And I noticed that there is no attorney present for Nucor. So I will take your remarks under advisement and assume that Nucor has no cross-examination since they are not here. All right. Let's do this. Let's go ahead and get Piedmont's evidence into the record, starting with the initial filings made. The commission does have questions for some of Piedmont's witnesses. So we'll introduce their testimony and get it in as we call those witnesses. And I am the questions that the commission has for the company's witnesses some pertain to most of them pertain to the stipulation and settlement agreement. Some pertain to rebuttal testimony. Some pertain to direct testimony in the event of a witness who hasn't filed rebuttal. But we could handle your witnesses at one time if that is if the parties have worked that out, and that's
how we
acceptable.
that's how we anticipated handling it for the company anyway.
Meaning we won't hold rebuttal. We can
Right.
address all evidence at one time. Okay.
Correct.
Ms. Yost, anything from
No
public staff?
objection.
Okay. And Ms. Yost, just for your purposes, I do think we will have a question or two for Ms. Boswell. So I'm just putting her on notice. I know she's back there and we'll call her up.
Would you prefer that the testimony that she was involved in be entered into the record through her, or shall we do it with the?
We can enter it through her, and we'll similarly, we'll enter Piedmont's witnesses' testimonies through their witnesses.
Good.
Okay. Well, with that, Mr. Jeffries, I'll go ahead. I'll take motions from you all.
Thank you, Madam Chair. Piedmont would move the pre-filed direct testimony and exhibits of Carl Newland, Jim Coyne, Dane Watson, and Paul Norman into the record at this time.
All right, Mr. Jeffries, I've heard that motion, and before I rule on that motion, I'd ask you to make a motion on application, et cetera.
That's fine, Madam Chair.
Put that in first.
I'm assuming you're asking us to move the application into the record.
Yes.
At this time, so we would so move.
Okay. And the attachments to that application, such as the G1 and the confidential provisions of the G1, will be admitted into evidence as well, unless there's objection.
No
And I'm hearing no objection. Just emphasize that portions of the G1 are confidential. All right. As to Mr. Jeffries' motion that the pre-filed testimonies of Piedmont witnesses Newland, Coyne, Watson, and Norman be moved into the record. I will accept that motion. The testimonies of these witnesses will be copied into the record as if they were delivered orally from the stand. The exhibits to those testimonies will be marked for identification as they were when pre-filed, and those exhibits are also admitted into the record.
And just for clarity on the record, Chair Mitchell, does that include the various supplemental rebuttal and settlement testimonies of that witnesses?
It
of those
does.
witnesses?
It does.
Thank
And,
you.
and just so that the record is entirely clear, I will go through the testimonies so that there's no later confusion. The testimonies include the direct testimony of witness Newland filed on April 1st, 2024, consisting of 20 pages and 3 exhibits. The rebuttal testimony of witness Newland filed on August 28th, 2024, consisting of 18 pages and 3 exhibits, and the settlement testimony of witness Newland filed on September 13th, 2024, consisting of 5 pages. In addition, we've got the direct testimony of witness Coyne filed on April 1st, 2024, consisting of 56 pages and 10 exhibits, and the rebuttal testimony of witness Coyne filed on August 28th, 2024, consisting of 40 pages and 6 exhibits. And then we've got the direct testimony of witness Watson filed on April 1st, 2024, consisting of 18 pages and 2 exhibits. The supplemental testimony of witness Watson filed on July 12th, 2024, consisting of 5 pages and 2 exhibits, and the rebuttal testimony of witness Watson consisting of, filed on August 28th, 2024, consisting of 3 pages. And then as to witness Normand, we've got direct testimony filed on April 1st, 2024, consisting of 18 pages and 3 exhibits. We've got the rebuttal testimony of witness Normand filed on August 28th, 2024, consisting of 4 pages. It's my understanding that company has provided testimony summaries for these witnesses. Is that the case?
I'm sorry, Chair Mitchell, say that again.
Testimony summaries have been provided for these witnesses?
They were filed in the docket G-9 837A
Okay.
yesterday afternoon.
All right. The summaries of the testimonies of those witnesses will be copied into the record as if given orally from the stand at the appropriate time.
Thank you.
All right. Any additional evidence the company needs to move in at this point?
I don't know if this is the appropriate time, but we would move the stipulation and exhibits into evidence as well.
Okay, we can do that. Unless there is objection, I'm not hearing any objection. Let's see. The commission will receive into evidence the stipulation of settlement filed in this docket on September 13th, 2024.
Thank you, Chair Mitchell.
And so the record is clear. The applicant filed a corrected Appendix 1 to the depreciation study on July 12th, 2024. The evidence moved in previously will include that corrected Appendix 1 to the depreciation study.
Thank you.
Okay. With that, let's go ahead and call your first witness.
The company calls Brian Weisker to the stand.
All right. Good morning, Mr. Weisker.
Good morning.
If you would raise your right hand, left hand on the Bible. Swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Go ahead.
Mr. Weisker, please state your full name and business address for the record.
Brian Robert Weisker. My business address is 525 South Tryon Street, Charlotte, North Carolina, 28202.
And by whom are you employed and in what capacity?
I am employed by Piedmont Natural Gas, and I'm the Senior Vice President and President of Piedmont Natural Gas.
And can you briefly describe your responsibilities to the commission?
So I'm responsible for all of the operations, gas supply, business development, commercial operations, our rates and regulatory aspects of our of Piedmont Natural Gas, as well as the natural gas business unit within Duke Energy.
Are you the same Brian Weisker that pre-filed direct testimony in this case on April 1st, 2024, consisting of 27 pages and 1 exhibit?
Yes.
Was that testimony prepared by you or at your direction?
Yes.
Do you have any changes to your pre-filed testimony?
I do not.
If I asked you the same questions as in your testimony, would your answers be the same?
They would.
And Mr. Weisker, in addition to your pre-filed direct testimony, did you adopt testimony in this case?
I did.
And are you the same Brian Weisker that was granted permission by this commission on September 12th, 2024 to adopt the testimony of Sasha Weintraub, whose direct testimony was originally pre-filed in this case?
I am.
And that testimony was filed on April 1st, 2024 by Mr. Weintraub, consisting of 16 pages.
That's correct.
And in adopting Mr. Weintraub's testimony, you understand the substance and details of that testimony?
I do.
If I asked you the same questions today that appeared in that testimony, would your answers be the same?
Yes.
And did you also pre-file a summary of your original direct testimony as well as the adopted testimony for the commission?
I did.
Chair Mitchell, at this time, we move that Mr. Weisker's testimony and his adopted testimony of Mr. Weintraub, as well as the summary of his testimonies, be entered into the record as if given orally from the stand, and that Mr. Weisker's exhibit BRW-1 be identified as marked and entered into the record at the appropriate time.
All right, the direct testimony of witness Weisker filed in the docket on April 1st, 2024, consisting of 27 pages, will be copied into the record as if delivered orally from the stand. The exhibit to that testimony will be marked for identification, as it were, when pre-filed. The testimony that Mr. Weisker has adopted, originally filed for Mr. Weintraub on behalf of Mr. Weintraub on April 1st, 2024, which consists of 16 pages, later allowed to be adopted by order of the commission by witness Weisker, will also be copied into the record as if delivered orally from the stand. And the summaries of those testimonies will be copied into the record as if delivered orally from the stand.
Mr. Weisker is now available for commission questions.
All right. Mr. Weisker, thank you for being here with us this morning. We have a few questions for you. As you are aware, your attorneys filed in this docket a motion asking that the commission allow you to adopt the testimony of Mr. Weintraub. In that motion, the company indicates that you have assumed Mr. Weintraub's duties. Is that in fact the case?
That is the case.
Okay.
Correct.
Can you help me understand? So walk me through sort of what those duties are and what your current title and responsibilities are for Piedmont.
So my current title is Senior Vice President and President of the of Piedmont Natural Gas. So in that role, I've basically everything that Sasha was responsible for, I'm now responsible for Piedmont Natural Gas. So that includes all of the operating functions. That includes our rates and regulatory team. That includes our sales and marketing group's responsibilities. Responsible for the financial outcomes for Piedmont Natural Gas. We have also in that group is our commercial development organization. Those are all items that I'm responsible for.
Okay. And does your authority extend to jurisdictions beyond North Carolina?
It does. It includes South Carolina and Tennessee under Piedmont Natural Gas, and then in Duke Energy, Ohio, and Duke Energy, Kentucky under our Duke Energy brand and gas operations in Ohio and Kentucky.
Okay. Mr. Weisker, your testimony in this proceeding explains in detail the investments the company has made since the last rate case in its system here in North Carolina. And your testimony, I'm paraphrasing now, but your testimony indicates a significant portion of those investments pertain to obligations that arise pursuant to the federal regulations. Have I summarized or paraphrased that portion of your testimony?
Yes, that's correct.
Okay. And in making those investments in your system and ensuring that your system is compliant with federal regulations, does the company work with the North Carolina Utilities Commission's pipeline safety section to ensure that you are complying with those obligations?
Yes, we do. So with the pipeline safety division of the commission, we work with them, ensuring that all of our system is in compliance with both federal and state regulations.
Okay, and your testimony touches on investments that the company plans to make. I believe it's through, it's either 2026 or 2027. It's escaping me at this point. but am I remembering that portion of your testimony correctly?
We talked through about that there'll be need for continuing to invest as far as from an integrity management standpoint, all through 2027 and beyond.
Okay, so do I understand your testimony correctly to mean that the company has identified needs through 27 that arise from its obligations under federal law to make investments?
That's correct.
Okay, and the company has every intention of making those investments?
Yes.
Okay. All right. Is there anything, you touch on this conceptually in your testimony, but what can you tell us, the regulator, about the state of Piedmont's system since the company has begun investments that are made pursuant to federal regulations?
Yeah, so I'll say overall, our system continues to comply with the federal regulations that exist. Federal regulations continue to change. There's rules that are promulgated, laws from Congress, and then PHMSA, Pipeline Hazardous Material Safety Administration. They develop the regulations to implement those laws from Congress. And so, over the, I'll say, last decade, we continue to invest in the integrity of our system to produce safe, reliable natural gas service to our customers, and that we stay in compliance with those regulations.
Okay, so do I understand your testimony to be, in general, you've made the investments in your system, you have confidence in the integrity of Piedmont's system?
I do.
Okay. And it is the case, isn't it, Mr. Weisger, that from time to time problems arise, that there'll be a line will be nicked, or other unforeseen situations happen that cause Piedmont to have to take action in the interest of providing safe and adequate service to its customers?
That is correct.
Okay. And can you help us understand, when those instances arise, you all have a good working relationship with the regulator here to ensure that they are kept informed about the problems and the adequacy of the response of the company to those problems?
Absolutely.
Okay.
We have a very strong process in that regard.
Okay. And good, you all have established lines of communication with the regulator?
We do.
Okay. All right. Mr. Weisger, just switching gears on you just momentarily, the settlement agreement. And you can look at this if you need to, but I'm just going to ask you a very general question. But the settlement agreement addresses cost of gas. It's section 3C of the settlement agreement. And the settlement agreement memorializes the terms that the parties have come to regarding the company's cost of gas. And there's a commodity cost and a fixed cost. And then the settlement agreement shows us the total cost of gas that you all have agreed to for purposes of this proceeding. The referenced in the settlement agreement is a level of gas usage for company used and lost and accounted for gas. Is this ringing a bell with you?
At a high level, yes, it
Okay.
does at a high level.
And
Correct.
my question really is, to be clear, do you recall that the settlement agreement references lost or company use and lost and unaccounted for gas?
I do.
And then it specifies a certain amount of decatherms that is attributable to company use and lost and unaccounted for gas.
Correct.
Okay. And the settlement agreement also explains that in calculating the cost of gas, there's a company use and lost and unaccounted for gas factor of 1.4463%. Do you recall that provision of the settlement
I
agreement?
don't recall the exact percentage, but I know that's part of the settlement agreement. Correct.
Okay. Can you help us understand, just explain to us how you all get to that percentage, and what is that company use and lost and unaccounted for gas? What do you all mean by that?
Okay. And I'll give a high level, but I think probably some of our accounting folks behind me can give you a better answer. But it's designed for from an accounting perspective, as far as what is the actual gas as metered coming in, and then the gas as metered to the customer and the delta between those two. And that's at a high level. I think either Ms. Powers or Ms. Cousins can probably give us a little bit, or Mr. Evans can give a little bit more detail into that.
Okay, and I'll ask them
Okay.
for the detail. So you just I'll ask you a few more questions about this and answer as you are able to, and then I'll follow up with Piedmont's additional witnesses. But why is there a difference between the gas that's coming in from your supplier to the gas that goes out to your the metered gas that goes out to the customers?
It could be for various reasons. It could be any type of a loss on the system, a leakage on the system. As far as you mentioned before, like a third party damage is the best calculating what we actually lose on that scenario versus what is calculated. It's also line pack, so that at any given time, so you have pressure on your system where, so if a pipeline operates and its pressure can be it can go all the way up to its maximum allowable operating pressure at that MAOP. It's got maximum line pack in it, so it has the most volume of gas compressed into it. At a lower operating pressure, that volume would be lower. So it's used to account for all of those, I'll say, the differences that can occur through the day-to-day operation of the system.
Okay, so the way I understand your testimony is there are multiple dynamics or multiple factors that account for company use or loss in unaccounted for gas. It's not just gas that escapes into the environment because
Correct.
there's a problem on the system.
Correct.
But it could include gas that escapes into the environment because there's a leak or something else happens, like there's a nick of the line or.
Correct. There could be a portion of that.
Okay, so the company has provided testimony in this proceeding regarding leak detection and advanced leak detection methods that it's utilizing. Do you all, let me ask the question this way. Is it the case that as you all grow more accustomed to to using that technology and, taking advantage of the opportunities it presents to the company and its customers, could we see that lost and unaccounted for gas that's attributable to the leaks? Will that come down? Can we see that factor come down?
I think in theory, we expect that to come down as we continue to evolve and drive, leakage off our system lower. Yes, I think that in theory, that's what we expect to see happen.
Okay. Okay. Well, we will, we hope that the company will report on its successes in that regard and keep this body, informed as you all move forward, and taking advantage of these new technological opportunities that exist. All right. Let's see, last set of questions for you. Are you familiar with the North Carolina Underground Damage Review Prevention Board?
I am aware of that.
Okay. And that body is not the commission, is it?
It is not.
Okay. But there's a lot of confusion that exists in this jurisdiction and elsewhere about what that body does versus what this commission does. And I'm not going to get into that with you while you're on the stand. But the question I have for you is this. When there are instances where Piedmont's system is compromised as the result as a result of an action taken by a third party, like somebody who's out there running fiber or doing whatever gets done out there, does the company have a process in place for making sure the Underground Damage Prevention Review Board is notified about those instances?
We do. I'll say that there's times that we make those notifications, repeat offenders, but yes, we do have an internal process to do that.
And is notification made to the board in every instance of an incident or only certain instances?
It is not made in every instance that our system is damaged, but only in certain.
Okay. Okay. All right. At the appropriate time in a future proceeding, the commission would like to learn more about what the company is doing in that regard to ensure that a maximum number or all instances of third-party contact with Piedmont system are referred to the Underground Damage Prevention Review Board. So I would just ask council to, I'm not directing anybody to take any action at this point, but we would just ask that you all work on informing the commission at the appropriate time in the future. All right, let me see if there are any questions from other commissioners for the witness. Go ahead, Commissioner Hughes.
Yeah, thank you. Just following up on the issue of leaks and just the general issue of emissions. While you're up here, could you just take a few minutes and talk about Piedmont's efforts with general emission reduction, particularly I know you have some direct emission goals, but also I believe you have some scope 3 emission goals as well as a company. And again, just while you're up here, could you give us a little bit of an update on where you are with those and if those are being, if you are tracking your scope 3 emissions, and if there's some place that I apologize if it's in the testimony that we could see what your current estimate of scope 3 emissions are.
All right, well, I'll start with what we're working on from advanced methane leak detection. So that is a program that we started, it's probably about 4 years ago, where we just started to build out a AMLD program. You'll hear that, advanced methane leak detection, and of use of satellite technology for us to be able to capture our system. With the satellite capture, it's very, very precise that we can find leakage on our system and then respond out to go out and do an investigation, pinpoint exactly where that leak is at, and then fix it, with the goal of continuing to go faster to really a find it, fix it approach, where we find leaks faster, we fix them faster, so that we minimize the leakage on our system. That's just one example of some of the things we're doing from an emissions standpoint. Another would be a technology, I don't think it was in my testimony, but around cross compression, where I have a pipeline that I'm going to take out of service, retirement, say, and another one that I've built, some of the projects that we've done from an integrity management, where we've replaced older pipeline with a newer pipeline. Historically, that when you took that older pipeline out of service, that gas would have been vented. And today we have a technology called cross compression, where, and it's exactly what it sounds like. I use a compressor where I compress the gas in the line that is being retired, and tie it into the existing line and compress it over, and basically take that pipeline down to, in essence, zero. It's usually right around 1 pound is how much you can cross compress that all the way down. So you use that gas is then not wasted. It's not emitted to the atmosphere. That's just another example of some of the work that we're doing. We've now installed just a couple of camera technology. So we're looking at how we could do that in an area of a stationary asset. Think of like a metering and regulating station. So that's an above ground stationary asset that we could have a camera that can look and identify and alert us if we have leakage. We're just starting with that technology and doing some testing of that capability. So those are all just some examples of the technology where we've come, and this is really just over the last 3 to 4 years. It's made significant improvements from a leakage standpoint. I don't think any of my testimony talks about scope 3 emissions. We continue to work and just trying to make our system, our customers, more efficient that they are in using natural gas. Then that'll be the better and more efficient that you are to reduce some of those scope 3 emissions as well.
Okay, I appreciate that, particularly the update on the technology. But as far as scope 3 emissions, I understand they're much more difficult to wrap your arms around. I do believe Piedmont has some goals in that area. So do you track those emissions? And again, I apologize if it's not your testimony, but if you have just a way that you could point me in the direction of where those that benchmarking is occurring.
So do we track? We track usage, and then therefore usage converted into into CO2 from what that, so how many decatherms that we deliver to a customer, and then therefore what that CO2 emission is. I don't recall exactly what goes into the EPA reports as far as, it has from a scope 3 standpoint. I don't think any of it does. So we do track it internally as we're building out basically a methodology of tracking both scope 1, scope 2, and scope 3 emissions. But I don't know outside of throughput that we post the scope 3 emission anywhere.
Okay, is that the same with upstream as well as you mentioned customer, but from the production?
The same as well. From I'll call that a scope 2 emission. So that we have certain scope 1 emissions that we have it's calculation based. Some of it that is reported out to the EPA in annual reports, but we're basically building out our system of how do we track those emissions upstream, downstream, quantify those emissions, and work towards our long-term goals of reducing those emissions.
Okay, well, I mean, if they do become publicly available, if in future times you point me in those direction, I'd appreciate looking at that and seeing what they are.
Understand.
Thanks.
All right, any additional questions for the witness? All right, questions on commissioners' questions?
No question.
Okay. From the company?
Just one question. Mr. Weisker, you talked about the technologies that the company is leveraging pursuant to its advanced methane leak detection. And you're a member of various industry groups like the AGA and others in your capacity prior to your current role in operations and now your current role. Is that true?
That is correct.
And would you say that the technologies that Piedmont is exploring and leveraging to be at the forefront of the industry?
Without a doubt, I would put us in the industry leading category as far as working to develop these technologies from a leak detection standpoint.
So we're not in a fast follower. We're at the front of that deployment.
Absolutely.
No further.
Okay. All right. With that, Mr. Weisker, we appreciate your time with us this morning, and you may step down.
Thank you.
This time we would move Mr. Weisker's exhibit BRW-1 into evidence.
All right. Having heard no objection, we will accept his exhibit into evidence. And you all may call your next witness.
Thank you, Chair Mitchell. Piedmont would call Ms. Pia Powers to the stand.
All right. Good morning, Ms. Powers.
Good morning,
If you
Chair Mitchell.
would, raise that right hand, left hand on the Bible. You swear your testimony about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Go ahead.
Ms. Powers, could you state your name and work address for the record, please?
My name is Pia Katharina Powers. My work address is 525 South Tryon Street, Charlotte, North Carolina, 28202.
And Ms. Powers, who do you work for and in what capacity?
I work for Piedmont Natural Gas. I'm the Managing Director of Gas Rates and Regulatory for the company.
Thank you. And are you the same Pia Powers that pre-filed direct testimony in this proceeding on April 1, 2024, consisting of 27 pages and exhibits PKP-1 through PKP-2?
Yes.
And you are also pre-filed rebuttal testimony in this proceeding on August 28, 2024, consisting of 13 pages, correct?
Correct.
And finally, settlement testimony on September 13th, 2024, consisting of 14 pages and a settlement exhibit PKP-1.
Yes.
All right. And Ms. Powers, were those testimonies and exhibits prepared by you or under your direction?
Yes, they were.
Do you have any corrections to your pre-filed testimonies?
I do not.
Ms. Powers, if I ask you the same questions that were set forth in your direct rebuttal and settlement testimonies while you were on the stand today, would your answers be the same as are reflected in those testimonies?
Yes, they would.
Okay. And you also caused to be filed with the commission yesterday a summary of your pre-filed testimonies, is that correct?
Yes.
Thank you. Chair Mitchell, we would ask that Ms. Powers' pre-filed testimonies be entered into the record as if given orally from the stand, along with the summary of her testimony filed yesterday.
All right. Having heard no objection to your motion, the direct testimony of witness Powers filed in the docket on April 1st, 2024, consisting of 27 pages, will be copied into the record as if delivered orally from the stand. The 2 exhibits to that testimony will be marked for identification as they were when pre-filed. The rebuttal testimony of witness Powers filed in the docket on August 28, 2024, consisting of 13 pages, will be copied into the record as if delivered orally from the stand. And the settlement testimony of witness Powers filed in the docket on September 13th, 2024, consisting of 14 pages and 1 exhibit will, the testimony will be copied into the record as if given orally from the stand. That 1 exhibit will be marked for identification as it were when pre-filed.
Thank you, Chair.
And the summaries of the testimony will be copied into the record as if delivered from the stand at the appropriate time.
Thank you, Chair Mitchell. Ms. Powers is available for questions by the commission.
All right. Good morning, Ms. Powers. We appreciate your being here with us this morning. We have a few questions for you, primarily related to the settlement and your settlement testimony. All right. The first one, you provide in your testimony, settlement testimony, it's on page 14 if you want to take a look, but you provide us with an estimation of annual residential customer impact associated with the numbers agreed to in the settlement.
Yes,
Do you recall that
I do.
provision of your testimony? Okay. And you indicate that annual residential customer impact under the terms of the stipulation is approximately $90 or $750 a month. Does that
Correct.
sound correct? Okay. So my understanding is in sort of well, let me ask the question. Does that customer impact pertain to year 1 post effective date of rates?
It does.
Okay. And how does the impact change in year 2 once the edict has gone away?
I'm sorry, I don't have a quantification of that with me.
Okay.
Certainly, there will be an increase, albeit a much smaller increase because we're seeking in year 1 the majority of the impact, and the 2 rider elements, the EDIT rider and the ENCNG rider, those, what am I exhibit here? So exhibit 1 to my settlement testimony provides on row 43 that essentially the fact that base rates are going to increase pursuant to the settlement by 97.9 million annually. And that's for all customers. The residential class gets a portion of that. And then we have these 2 rider elements, which are shown on rows 44 and 45. So that nets to an $88 million increase. And so the cited customer impact was year 1 associated with that 88 million, but then there is the additional, those 2 riders dropping off in year 2 and thereafter. I don't have the quantification, but it would be a small impact relative to what's happening in year 1.
Okay. Recognizing that you don't have the quantification and perhaps haven't done that calculation, can you help, give me put it in ballpark terms? I recognize I'm asking you to speculate and estimate.
Yeah, so 10, the revenue requirement as a whole is increasing by 10 million, bringing you to 100. So I mean, that's less than, it's around 10%. I'm really bad with math in my head on the fly.
Okay.
And so if I'll just ballpark it like this, I would guess, subject to check, that it would be an additional, additional 10% of that 750 would go back on.
Okay.
Witness Cousins may, I don't know, but she perhaps might have a specific calculation prepared.
Okay.
But
I'll ask her and I'll see if she takes issue with your math on the fly. So she can clean that up if she does.
okay, and that 10% reference, that's simply like 10% of the increase happening in year 1, you layer on
Right.
another 10%.
Okay. All right. Thank you, Ms. Powers. And when you all calculate the customer impact, the residential customer impact, what assumptions are you making there about usage?
Yeah, so the way it's been calculated for this proceeding, consistent with the public notice, was done at a high level, but it comports with a bottom-up view as well. So we look at the number of customers that we have presently on our system, and take the revenue requirement that goes to the residential class and divides it by the number of customers. That's a very high level, call it back of the envelope calculation. But ultimately, what underlies all of our calculations here is weather normalized usage. And so I believe the weather normalized residential usage is approximately, got here, a little over 500 therms a year.
Okay. And so some customers that have a heater that's fired by natural gas and cook with natural gas may use more than other customers, residential customers that use only gas for cooking and other less intensive uses than home heating.
Yes, the residential class of customers, certainly there are variations in usage driven by their behavior, the equipment that they have that's gas consuming, whether they're gone on vacation and during what season. There's a lot of factors that play into it, but in general, the residential class of customers is more homogeneous at a high level than, say, the large general class
Okay.
of customers.
All right, that's
And-
helpful.
And so the average that we use, I have it here, it was on a weather normalized basis, and we refresh in each general rate case the computation of what is normal weather. It's a 30-year average. And so it's the usage by the residential class for the typical or average residential customer on an annual basis is 537 therms a year. And there's a base load factor and a heat sensitivity factor. So if that's representing a single average, you're going to have some that are below that and others above.
Okay, thank you for that explanation. Okay, and I'm going to ask you this question, and if you want to refer the question to Ms. Cousins, that's perfectly acceptable. Can you help me understand in the context of the cost of gas? So the settlement addresses cost of gas. You've got the commodity cost and you've got the fixed cost. What is the fixed cost of gas?
Fixed cost of gas, sometimes we refer to that as the demand cost of gas. Essentially, it is made up of a couple types of charges, and settlement exhibit G delineates that. The majority of the charges pertain to our capacity contracts for transportation and storage on Transco and other suppliers. So those charges are fixed charges we pay on behalf to provide service to our customers regardless of the usage. So they're fixed charges to those providers. So when I look at Exhibit G, as I referenced, that amount for transportation comes to approximately $115.7 million. And that's the North Carolina portion. And you would see that on row 41, column I. Then the storage charges that we provide, that we pay to, again, these are mostly FERC regulated entities. So we're paying, for the most part here, FERC tariff approved charges. So for demand on storage, we add in also some of Piedmont's LNG capitalization cost to that, but that sums to approximately 31.5. You would see that million. You would see that on row 61. So those are primarily the costs that we record to the cost of gas deferred account. And what we're doing here with this rate is we have a practice in every general rate case to refresh that base rate to the going level, really in the hopes that then it minimizes future deferred account activity on this matter. So we took the current rates for those entities, FERC and NCUC regulated rates here that we're paying. And we also layered, so that's what we've got the summary there. We also layer in anticipated level of secondary marketing credits. And since the last rate case, that anticipated level of secondary marketing credits that offsets that cost has increased. Let me say it's a good number, like you're offsetting with a larger number than we had in our last case. And so when you sum that up, as shown on row 63 of that schedule in column I, it comes to an expectation that our annual level of fixed gas cost is $87.2 million for our North Carolina customers. And just for comparative purposes, in the last rate case, that similar schedule was shown on Exhibit I of the stipulation in our 2021 rate case. And so the comparison point to that 87 million would be 126.4 million at that time. So costs have come down partly from what we're paying the pipelines, as well as the increased credit associated to customers associated with the secondary marketing activity.
Can you help me understand the increased credit from the secondary market transactions? It is in general a good thing.
Yeah.
But why is that happening?
I can give a high level explanation. I also want to recognize that Piedmont's subject matter experts for this area, they are the experts that are in our annual cost of gas proceeding. That hearing is coming up. And so you'll have an opportunity to speak to the SMEs directly there.
Yeah.
But ultimately, it relates to the value on the secondary market of Piedmont's capacity. So if we release or use asset management agreements, there's a variety of secondary marketing activity, but the fact that the credit is higher recognizes the higher value of that capacity in that secondary market.
And Ms. Powers, will you refresh my recollection on those secondary market transactions? I understand that, or at least as I understand it, Piedmont goes out and procures transmission capacity.
Under long-term arrangements, typically under these contracts. Yeah.
Under long-term arrangements. And then to the extent Piedmont does not need that capacity and at any given time, it can then sell that capacity on what we call the secondary market. Is that correct?
Yes.
Okay. And so it might be, so let's say hypothetically Piedmont has a 10-year contract for certain transmission capacity rights. And in 1 year, it does not need that transmission capacity. It could release or could sell that transmission capacity for that 1 year.
Conceptually, that's the case. I think you're starting to get to the limit of my expertise because there are asset management agreements that come into play in all of this. And again, the witnesses at Piedmont's witnesses at that proceeding can get to the more granular level of the market there for you. But at a high level, what you're describing is accurate.
Okay. When a credit occurs, as we see in this case,
Yes.
Is that because Piedmont has let me say it this way, has resold that transmission capacity for more than it initially paid for it?
I'll share it as in that market, we're experiencing a gain, and pursuant to other commission orders, we credit the amount that customers we're recovering these costs from customers. So to the extent in secondary marketing transactions, we experience a gain that offsets what we need to recover. So that the credit occurs on our deferred accounts or deferred cost of gas accounts. But rather than wait for that to be experienced, we recognize we can have a better going level base rate if we recognize that there's going to be some credits that will flow through and we layer that into our base rates here. That practice we've been doing now for several rate cases.
Okay. And I guess ultimately my question is, so to the extent that customers have already paid for this capacity, is it being resold at a higher rate than what they would have paid, or now they just paying less for the capacity that they're not using? Does my question make sense?
I think what I'm hearing your question get to is the value of the capacity. And I don't want to misspeak because I'm not close to those level of details.
Okay.
But ultimately, if you have an asset, how I like to think about it, if you have an asset that you don't need at this moment, to the extent you can offset that cost by reaping rewards in a secondary market, it all benefits customers.
Okay. All right, thank you. And I'll stop there and we'll ask the questions in the gas cost proceeding. Okay, let's see. Turn back to my notes here.
I have some context on the LAUF whenever you're ready.
Okay, let's go there then. So you heard my questions of Mr. Weisker about the LAUF. Is there anything else that you'd like to add to his explanation of what that is? And why customers why we ask customers to pay for it?
Okay. So LAUF ultimately, so what we collect, we ask customers to pay for is company use and lost and unaccounted for. I think that combined acronym CU and LAUF. So company use is essentially measured usage because I'm combining that and I'll get to the LAUF in a second. So we utilize gas in the course of operating our system. In simplest terms, if there's a usage of gas for whatever purpose at Piedmont facilities, that's measured, and hence we have to collect that cost. The cost of gas is collected through our gas cost recovery mechanism, Appendix A of our service regulations, so it's not part of base rates. And we characterize it as a portion of it, but ultimately everything is trued up pursuant to the trued up to actuals pursuant to the operation of Appendix A. So the lost and unaccounted for portion is the portion that we cannot measure, but we estimate it by looking at how much gas flows into our system from the various supply sources relative to what we're metering. And that difference is the lost and unaccounted for, which does have some variability over time. But it's been relatively stable the past couple of years. At a high level, that lost and unaccounted for percentage, we reference it in a moment. About half of that approximately half of the company use and lost and unaccounted for would be lost and unaccounted for. Right now that splits about even. What causes lost and unaccounted for, Witness Weisker had a very good explanation. I'll just supplement. At a high level, it's what drives that difference between the amount of gas flowing in our system versus what is measured and billed, and also used by Piedmont in a measured capacity as company use. And I think changes in system pressure and temperature can account for some lost and unaccounted for gas, as does imprecise measurement by meters. Like there might be billing that is not precisely capturing the actual quantity and heating value. Changes in customer usage by cycles like that can drive it as well. Natural gas theft, as well as damages to the pipeline system leaks. So I just wanted to clarify that leaks, whether they be from damages or other, is not the only source of LAUF.
And is the intention or the goal of that gas factor, LAUF, CU and LAUF gas factor, is it to make Piedmont whole?
Yes, it's not meant it's exactly meant to keep us whole. If you think about that framework I just shared, that there's gas coming into the system. Well, that was gas purchased. So there's a dollar cost associated with that. And then there's what flows through customer meters. So that difference, company use, we need to be kept whole for the cost of the gas incurred for company usage. And that's not part of our base rates. So hence this is the avenue and the vehicle through the operation of Appendix A, our gas cost recovery mechanism, that we collect it. And then also to be kept whole for the lost and unaccounted for that is frankly a cost of operating the business. And, I personally would love it if that number was zero, but I think what I do see is that we have a very low LAUF percentage compared to many of our peers given the age of our system, for many factors, including all of the efforts we make as a company to mitigate the sources of LAUF.
Okay. All right. And since the parties have address the gas factor in the settlement agreement. I assume that there's consensus around that number, and so I won't probe that any further, but do you anticipate, I will ask you this, do you anticipate as the company continues to make investments in its system pursuant to PHMSA regs and, just annual sort of regular replacement of aged out assets, in combination with leak detection methods, should we see this number come down, at least the portion of it attributable to leaks?
I'll go with my colleague, Mr. Weisker's response. In theory, yes. Like I said, because there's a variety of drivers of what causes it, some of which is leak. I think those activities should produce that, all else being equal.
Okay. All right. Well, again, I'll ask you, like I asked Witness Weisker, just keep the commission posted on the company's efforts and
Will do.
successes here and getting this number down as low as we possibly can. Okay. The settlement agreement addresses certain deferrals. And I want to ask you about some of those. And I'm looking at page 10 and 11
Of the settlement agreement?
of the settlement agreement, yes. Okay, so I want to make sure I understand the agreed upon treatment of PIM-T and PIM-D. So the existing PIM-T and PIM-D, not going forward. Existing, you've got amounts to be recovered, and for PIM-T, you've got 63 million plus, and for PIM-D, you've got 37 million plus. Does that sound right?
Yes.
Okay, so the company and the public staff have agreed to a cost recovery mechanism whereby you'll amortize those balances over a 10-year period. And so that to be recovered in rates established in this proceeding. The unamortized balance remains in rate base. Is that correct?
Yes.
Okay.
We're seeking to recover our current unamortized balance or the unamortized balance referenced here over 10 years. But the deferred account on which the balance currently sits is an account that's included in rate base.
Okay. All right. And I assume that during what we think of on the commission as the deferral period, as it's sitting in that account waiting to be recovered, but before it's been amortized, that amount is accruing a return. Is that correct?
Yeah.
Okay.
By virtue of being part of rate base and that was used to establish rates in the stipulation.
All right, thank you. Going forward, the going forward costs, expenditures associated with PIM-T and PIM-D will be deferred into a single account as opposed to having those two separate accounts. Is that correct?
Yes.
Okay. And will be recovered alongside the IMR. Is that correct?
Yes, we'll have a new tariff, a new rider mechanism that will memorialize the terms of that in the tariff. I think there's a sentence in the stipulation that says when we would file that. It's at some point shortly after the commission's order in the proceeding.
Okay.
And that will walk through the exact timing, but the intent is to have twice a year rate updates to refresh it. So it is very recovered on a timely basis, and that for those twice a year rate updates to happen concurrent with the IMR rate changes.
Okay. And PIM-T and PIM-D pursuant to this new recovery plan or to the recovery plan agreed to in the settlement agreement would not be in rate base. And those are expenses that would be recovered through this rider mechanism that you all have agreed upon.
Yes, and to clarify that point, it's all of our expenses that are eligible for this treatment, this deferral treatment, but incurred on or after July 1st, 2024, because the cutoff of what we're using in base rates in this proceeding is June 30th, 2024.
Okay, thank you for the clearing up the record. Okay, let's see. So for the deferred, the amortization of deferred costs for environmental activities, now I'm on page 12 of the settlement. It's the same thing there. You've got a deferred, a deferral, unamortized balance earns rate base. I mean, I'm sorry, earns its return sitting in rate base. Okay.
Yes.
All right. And just conceptually, or can you refresh my recollection, the environment, is that for the company's manufactured gas plant liabilities?
Yes, that is a large component of typically what we have been deferring
Okay.
pursuant to I think it was a 1992 deferral order from this commission. And so manufactured gas plant, underground gas holders, all of that very old, old infrastructure and the effect from an environmental perspective of that and the liability associated with it. But there can be other environmental matters that come up over time.
Okay. So this is a holding place for any environmental liabilities?
Environmental clean, the language in the order uses the, environmental cleanup is my quick
The
shortcut.
1990, are you referring to the
The
1992 order?
1992 order.
Okay.
And Piedmont has a requirement it's fulfilled to provide the public staff an annual report. So they're seeing annually a description of what we are recording to that deferred account, and the invoice is supporting that.
Okay. All right. Customer Connect, so my understanding is in the last supplemental filing, in the last supplemental update, and let me say that clearly, in its final update made in this proceeding, Piedmont indicated expenditure of 13-ish million dollars, and now the settlement agreement has 15. So I'm trying to understand the discrepancy between the 13 and the 15 million. But is it the case that so I assume because the parties have agreed on the 15 million, 15,885.
So that amount represents the actual costs that the North Carolina portion of the actual O&M expenses associated with that project through June 30th, 2024, which then we're amortizing over a multi-year period in rates. I don't have an answer for that delta. Witness Evans might, but I don't have that
Okay.
that reconciliation explanation for you.
Okay. And again, on this deferral, have the parties agreed to allow the unamortized balance to earn a return?
Yes, it's
Okay.
included in rate base.
Okay. Okay. Okay, Ms. Powers, walk me through. So the settlement agreement addresses unitization and the company's efforts towards unitization and the public staff's concerns with unitization. But can you start from the beginning there for me? What is unitization and why does it matter?
Yep. So just as a caveat, I'm not a accountant or CPA, but it's obviously something I've had to become very familiar with for rate regulatory purposes over the years. So when a project is placed into service, all of the and so we often talk about the in-service date, and we've got in-service date for cutoff in rate base and rate cases. Not all of the costs have actually been received by the company and recorded yet. So that takes time to run that process. And then there's for lack of a better word, a review by accountants before they close the project. They're going to make sure that they've captured all the costs and they're recording all the costs to the appropriate plant accounts, and there isn't inadvertently a cost unrelated to that project that's in the numbers. So think of it as it's the unitization process. I refer to as the process that occurs on the accounting side from a due diligence and review after the project is placed into service. So what the parties have agreed to here, if you're ready for me to move on to that. The parties have agreed to here is that Piedmont would complete that unitization process under a specific timeline, that 90% of projects would be completed within 12 months of the date that the project goes into service. That's the unitization standard that we have aligned on and memorialized in the stipulation. I guess one other fact I'll point out is the way one can see what has been unitized or hasn't been unitized. If it's in service, it's sitting in our balance sheet, on our balance sheet in either plant account, I think there's a FERC account, 101 or 106. So 106, the phrase for that account, the name of that account refers to it not being unitized yet. It's in service, but not unitized. And then once it is unitized, it's transferred to account 101. So that's how one would see it on our financial statements to understand what the balance is of what has not yet been unitized. It would be looking at what is in account 106.
Okay, so why is it important to customers? Well, let me back up. Why is there an emphasis on minimizing the amount of time between when plant is placed in service and when it is unitized?
I would share that. I would say we know that it's important to the public staff. They've raised it on occasions, including in this proceeding. What underlies that importance to the public staff, I would defer to the public
Okay.
staff witnesses.
I'll ask that question to Ms. Boswell. But so in testimony Piedmont filed in this proceeding, there was mention of a previous, I think it was an order of the commission where there was an understanding that Piedmont would unitize within 180 days. Is that, am I remembering that correctly?
Yeah, I think that language, that order, I think it was 2016 is the date of that order, and Piedmont has been filing reports with this commission twice a year pursuant to the language in that order. The terms in that can be confusing, so if you'll bear with me, I'll clarify that. And as knowing that it's confusing, because I could see that it had this potential back in 2016, what I'm describing now is also described in each of those biannual reports, because I wanted to be abundantly clear to this commission when we filed it. So that the completion of the project happens within, our target is to complete the project within 12 months of the in-service date. So, or to unitize it within 12 months of the in-service date. We also internally target completing the project, recording all of the charges to it, so that then that due diligence review can happen within 6 months. I think that's 180 days of the in-service date. So it goes into service. Think of that as day 0. We target completing the project by the 6-month mark, and then completing the full unitization of it by no later than 12 months. So I just wanted to clarify, think of it as a day 0, 6-month, and then 12-month. That completing the project, the 180 days you referenced, that would be that second half of that 6-month period.
Okay. And so in the settlement agreement, the 12 months is the
From the in-service date.
okay. Okay, and there are, the company has agreed, that the parties have agreed to certain terms associated with the timing of unitization. And we had a question about sort of what happens if 1 year you don't meet the standard, what happens to the costs that of those projects that the company incurred, but for which you didn't meet that standard?
Yeah. So Piedmont and the public staff, obviously we and the other parties, the stipulating parties, we have the language in the settlement agreement. But what we intend to do, and I think it was also, I can't remember right now if it's in the stipulation or just my settlement testimony, but we're ultimately going to file language in the IMR following the commission's IMR tariff, following the commission's order in this proceeding to make this abundantly clear exactly what we're doing and when regarding unitization. I can describe for you now at a high level what the intent of the language in the stipulation is, if you would like.
Please do.
Okay. So if you think about, so the way this unitization standard and how it would apply in the IMR, ultimately you'd have to think about the cadence of our IMR filings. So but next year in the fall, I think it's October 31, Piedmont would be filing its IMR rate change to effective December 1. So we'd make that filing on October 31 for effect and rates December 1, IMR rates. That's going to be based on our IMR plant investment that starting with July 1, 2024, like the day after the cutoff date for this proceeding, through to September 30th of next year. So multi-month period, a little longer than a year of investment. At that point in time, we would be, if you want to know how to come up with this, characterize what the 90% is, whatever that plant investment is, that represents what we're putting into rates in the IMR for December, effective December 1, 2025. There's going to be a portion of that plant that has been unitized. There would also be a portion of that plant that really hasn't been unitized yet, but it's still not untimely. You know, the 12-month clock hasn't played out yet for it. And then there could be a portion of that plant that the 12-month clock has already played out and now it's untimely. It hasn't been unitized yet. I'll use the phrase for ease here. It's past due for unitization. So what the standard we've agreed to is if that past due amount is, one way to look at it is if the past due amount is greater than 10%, then that amount above the 10%, say it's 12% of the projects that have gone into service as of that IMR cutoff date next year, September 30th, 2025, are past due. Then the 2%, the amount above that threshold, would not be eligible for a return. So our revenue requirement computations would exclude the return on that portion of the plant.
Okay. Thank you. That's helpful. There's mention of penalties, and it's in the settlement agreement. So I'm not going to ask you to delve into it significantly, but I assume that whatever filing you all make in the IMR proceeding that fleshes out how you all are going to implement this settlement agreement will address the instances or the criteria under which the public staff would ask for a penalty. Is that correct?
Yeah, can you give me a moment just to look at the stipulation?
Sure.
Thank you.
Look at page 17.
Okay. Okay. So on page 16 is where section W unitization begins. So subsection 1 under W refers to how it would operate under the IMR. I don't see that we use the penalty language there. It's just referring to how I'm going to begin in the middle of that paragraph.
Okay, you're right. I see
Pro
that.
rata
You're
portion
right.
that exceeds the 10% won't be eligible for a calculation of return. Paragraph 2, the following paragraph is where that word penalty shows up, and that would be at the public staff's discretion if they felt one was warranted, and that would be associated with capital projects not eligible for the IMR or a rider. So how I interpret that would be how they're looking at our unitization standard for non-capital projects, non-IMR projects in a future general rate case.
Okay, you said non-capital projects, but you mean
I mean,
non-IMR.
Non-IMR, non-capital rider. We don't have any other capital riders
Right.
today besides the IMR.
Okay.
But
Got it. Okay. All right. Thank you for that clarification. Okay, let me check. I think I'm through my questions for you, Ms. Powers. One last question or set of questions for you has to do with the public staff's testimony regarding affordability. And you addressed that some in your testimony, but the way I recall the public staff's testimony is they expressed concern that Piedmont has a greater number of customers who are either in arrears or on a payment plan than any of the other LDCs. Do you recall that testimony?
yes.
Okay. And can you help me understand why that may be the case?
Frankly, I have not validated the public staff's numbers, so I'm not sure if that's the case or not. I recognize that I haven't done the research to validate what they have written there. But certainly, Piedmont always has a certain number of customers that are in arrears, maybe subject to disconnection for non-payment. High level right now, I don't think that percentage right now is greater than it has been over the past several years. So I haven't seen a spike in that percentage for Piedmont, but I can't compare it to the other utilities. I haven't done my own homework on that.
Okay. And is it the case that Piedmont offers assistance to its customers that are having trouble paying bills, such as payment plans?
Yes. So certainly we have the equal payment plan. It's part of our tariff that describes eligibility for that. That you don't have to be in arrears for that. Anyone is eligible to opt into that voluntary program to spread out their bill over time. But for customers who are experiencing difficulties paying their bills timely, we do work with them to be able to connect them with sources of funding for bill assistance, agency funding.
And can you describe that process for me, the process by which the company is working with its customers that need assistance?
That process, certainly if a customer were to call Piedmont through the phone and speak to a customer service representative, there would be information shared with the customer on how they could apply for that funding through, I don't believe Piedmont has the application process. It ultimately entails the customer going and reaching out to an assistance agency in their county where the funds are accessible to them. And so the process involves providing them the information of how to reach those agencies. There might be more than, I think we also have that information accessible on our website and perhaps other means of communication. That's the extent of my knowledge on that. I'm not in the customer organization, so I don't know these firsthand. I guess that's my way of saying I'm not the SME for this, but this
Okay.
is how I understand the process to work.
Okay. All right. Thank you for that response. Okay. I appreciate your answers to my questions. I have nothing further. Let me see if there are any commissioners. We'll see. We'll start. Commissioner Hughes and then Kim Wright.
Thank you. Just a couple follow-ups to Chair Mitchell's questions related to usage and variations, and they tie to affordability as well. If I understood your what you said a few minutes ago, the weather normalized usage is, I think you said 537
For the residential class therms.
So I think, am I correct if I simply divide that by 12 and kind of come up with a 45, roughly 45 therms per month?
I mean, that can be used as a metric. Of course, the usage is seasonal, and so
Well, that's
majority
where I
of
was
the
kind of going.
usage is in the winter season.
Well, so that was my question. If on average it's 45 therms per month. I'm assuming a lot of the numbers that are presented in your testimony are based on that 45, like the $7.50.
Yeah, the seven, and then that's the tricky part of like, of representing the bill impact. It's very easy to look at it annually, the $90. But, we levelized it, divided it by 12 to get the 750 for just simply ease of having one data point to communicate with. But you're right, it is going to be impacting the customer differently depending on the season and even within the winter season, depending how the weather.
Well,
plays out.
I appreciate that. I'm just trying to get a gut feeling of the impacts. Do you have offhand what the average is in your highest use month versus lowest use month? Like, is that something readily? So it's not 45, I would imagine. Is it 90? Is it triple? Is it
So-
quadruple?
I think one way I can shed some light on that for you is we typically, for each class, we'll look at their baseload usage. Think of it as non-weather impacted usage. And then there's their heat sensitive usage. And so heat sensitive usage is what we recognize through regression analysis as every heating degree day incurred, there would be usage per heating degree day. So 1 heating degree day is when the average temperature is 1 degree higher than 65. 65 is the level setter there, or 1 degree lower than 65, excuse me. So on that, in that framework of that 537 therms, approximately 438 of them are heat sensitive. Remaining 99 would be baseload usage. And again, that's representative average residential customer. We don't have a typical, like there's so many different variations. So we just have one average that we represent through our regression analysis for the residential class.
Okay, well, and thank you. This is all interesting. In simplest terms, do you just have is it in the coldest winter month, is the average 90 therms, or is it 120 therms, or I mean, just simple bill frequency, looking at the bills that go out. Do you have a rough?
I'd have to do that in my spreadsheet at my desk.
Okay. I'm just trying to get,
We have the data. It's certainly all what we're looking at in rate cases when we're refreshing what our weather normalized usage is, because we use it in many applications and many mechanisms. We ultimately do look at it by month. And so we would be able to have that data to be able to look at that. I just don't have it at my fingertips to share.
Fair enough. All of these questions, just so you know, all these questions get at this issue of cash flow for customers, and what you've already cited a few times of
the winter season is the hardest season because of the higher bills. Naturally, even without a rate change, that you're going to have customers experience higher bills in the winter because their usage is higher.
Well, the two things in my head I'm trying to wrap around. One is the customer assistance program, which I believe is $32, is possibly or up to $32 per month during the winter months. I'm trying to get an idea of what kind of bill impact that will be in the winter months, not averaged over, the entire year. So that's where I was going, and compare that to actually the bill increase, because I think we might hear from customers, there's this amount of bill increase in February, and then is that bill increase, for example, is that higher or lower than the 32? I mean, certainly $750 is lower than 32, but if they're using a lot more in the winter, it could be that they're actually not going to even see that much of a change. Does that logic make sense? That's what I'm looking at.
Commissioner Hughes, it absolutely does. Don't have that information prepared and gathered in a way to share with you today, but certainly those are calculations that can be performed.
Well, I'm not going to ask for a late filed exhibit, but I believe there's going to be a subsequent filing for the customer assistance program and I would ask both you and the public staff to, when that comes in, provide more information on a, bill frequency analysis, kind of month by month impact. Does that make sense? Is that
Yes,
appropriate?
I agree. It is. And we will take that into our consideration with what we put together for that filing. That makes a lot of sense.
And this is the last thing to add to that. The equal payment plan also seems to have a big impact on that. So do you have a rough idea? Is it 15% of the residential customers or 40% of the residential customers that do that equal payment plan? Because I think that trumps everything else. If they're doing the equal payment plan, then their monthly usage is not going to be, have nearly the
Yeah,
bite
it's
on.
spread out over the year. I mean, their usage by month is the usage, but we're ultimately
Yeah.
spreading it over the year. I don't have that exact stat in front of me, but I think rough order of magnitude would be something between 10 and 20% of the residential customers, and subject to check, are in that. I do not believe that we have a participation level in North Carolina from the residential class at 40%. It's, like I said,
Okay.
between 10 and 20, I believe.
Well, just again, if you could roll that into the customer assistance analysis, because obviously if folks are on that plan, then any customer assistance is going to have a bigger impact as a percentage.
Understood.
The other thing, again, probably for this follow-up, is I understand that there's some tension between LIHEAP eligibility and utility customer assistance programs, so that some LIHEAP eligibility and access is linked to the actual size of a customer bill. And I may have this wrong, but I understood that when you do start providing customer assistance programs, there's the possibility that reduces the customer's bill, and that reduces their eligibility for LIHEAP. So from their perspective, they're not necessarily seeing a net gain. That'd be something I would like to learn more about in the future, again, as you're moving forward this. I don't know if you know the answer to that now, but something that I'm curious about.
Yeah, we would look into that. I don't have an answer for you on that right now. Thank
Okay.
you.
No further questions. Thank you for that.
You're welcome.
Good morning, Ms. Powers. Just a couple of questions about the customer assistance program.
Yes.
And from reading the testimony, it's my understanding that the public staff had requested that Piedmont consider a customer assistance program, and that's how it ended up as part of the stipulation. Is that correct?
It is.
Okay. And then I believe this is paragraph V related to the customer assistance program. And the details and parameters of that customer assistance program have not yet been developed, but will be jointly developed with the public staff. Is that my understanding?
Yes, that's correct.
And I just had one question about the funding for the program, and the stipulation talks about Piedmont will be funding up to $1 million for the first 3 years of the program.
For each of the first 3 years.
For
Yes.
each of the first 3 years. Will there be funding from other sources, or is the funding in total going to come from Piedmont? Will it be $1 million each year total for each of the first 3 years, or do you know yet?
Do not know yet. The stipulation was only referring to the Piedmont funding of it, whether there would be at a $32 bill credit level, whether there would be, and coupled with the number of qualifying customers, which we don't have a number for that yet with certainty. So that was the number of qualifying customers, and determining that is with more certainty is TBD, and will ultimately be information to understand whether or not Piedmont's $1 million annual contribution will be sufficient per year. So more to come on that. There's a lot of unknowns that we need to work through with the state agencies to better get a finger on the pulse of that, to then determine next steps.
Okay. Thank you.
You're welcome. Thank you, Commissioner Kimmerer.
First, let me thank you for your testimony today. It's been informative.
Thank you.
My questions also arise related to this customer assistance program. As things currently stand, can you go into any detail in terms of what has been preliminarily discussed about the way eligibility would be determined for customers participating in the program? I mean, obviously, with the Duke program that's a pilot at this time, that's also 3 years. I mean, they look at people who are SIP eligible or LIHEAP eligible. I don't know if with the program you all are contemplating at this time, what eligibility requirements have been preliminarily discussed. And likewise, I see that we're saying up to $32 a month, and that
Yeah.
I don't know how that impacts, ultimately the consumer in terms of the benefit they're going to actually receive, kind of based upon some of the questions Commissioner Hughes asked about, what the bills might actually be. Mhm.
Commissioner McKenzie, those are very good questions. We have not had preliminary discussions yet, even to vet through that with public staff raising this pursuant to this proceeding and ultimately it making its way into the stipulation. There are a lot more conversations to come. That would be something we would inform the commission with the compliance filing that we have cited here. So I don't have answers to those questions. I'm aware of Duke's program, and we're not looking to reinvent something. We're looking to put together a program that supports our customers, in the best way possible and to in consultation with the public staff. So I don't have an answer for you on those details, but they will need to be sorted out in order to put together more details on how the program would operate.
Well, I certainly look forward to seeing that specificity.
Absolutely.
In terms of the value of a program like this, I think the need is obvious. And I'm glad to see that in the stipulation, there is a concurrence that this type of program will be implemented in the near term. And I guess the next 6 months, we'll wait to see what the details look like.
Yes, thank you.
Thank you.
All right, any additional questions for the witness? Oh, go ahead, Commissioner Tucker.
Thank you, Madam Chair. Ms. Powers, again, thank you for being here this morning and answering questions. I'm new here, so I'm just trying to go through it. As you can see on the chairs in front of her, the reading that's available for each rate case is unbelievable. But as we delve through this, back to your testimony on page 11, line 13, I just want to understand something.
Give me a moment, I'll go there.
Sure. Settlement testimony now.
Would you share that reference again?
Page 11, line 13.
Yes.
Okay, so this morning we discussed the fact that the ramification of the increase from Piedmont, I guess in the first year would be roughly $750 a month or $90 a year, give or take. That's not exact science, but generally you're trying to come up with some sort of idea of what the impact is. And then I read here in your testimony about Piedmont is reinstating the bill presentment to pay for electricity for Piedmont energy reliability centers. Is that correct?
I think the bill presentment of the $10 is something different than that electricity matter pertaining to our energy reliability centers.
Okay, so it states here that it's being reinstated. Does that mean that the bill's going to go up $17.50 a month?
No, it does not. I'm happy to elaborate if you're ready for me to do so.
Sure.
Okay.
I mean, that's
Thank
what
you,
I'm
Commissioner
asking.
Tucker. So for residential customers, Piedmont bills the customers. There's two components of the bill, and this is not new. It's been like this for many years. Ultimately, there's a fixed monthly charge of $10 that goes toward Piedmont's recovery of a portion of its cost of service. And then there's also volumetric rates. the majority of what Piedmont collects is through volumetric rates, a rate per therm. And prior to July 8th, 2024, when a customer receives their bill, they saw two line items on the bill. One, the $10 for residential customers. They saw the $10 monthly charge as a line item on the bill, and the separate line item would be the dollar amount associated with the volumetric charges. There was a change that began July 8th where just from a bill presentation that all got bundled, and pursuant to the so the customer didn't have separate visibility on their bill to that $10 charge. It's still being charged. It just wasn't shown as a separate line item on the bill. I think I agreed to that. I presented this in my rebuttal testimony, but it certainly made its way into the stipulation as well, that Piedmont agrees to, pursuant to the public staff's request, to reinstate having a separate line item on the bill for the $10 monthly charge.
Okay,
So it's not a new charge, it's just showing it on the bill distinctly as its own line item rather than bundled with the volumetric charges.
okay, so as I read this, what you're telling me is that the reinstating really is not what's happening. You're telling me that the $10 has been there all along for Piedmont. And that you are simply just breaking it out on the bill. Is that what I understand?
Yes, I believe public staff testimony sought the reinstatement, and so I used that phrasing to underscore that we were obliging public staff's request.
Okay, well, that clarifies that for me. What about the electric service cost for the energy that is required to operate Piedmont's Energy Reliability Center? Is that some charge somewhere else, or is that in all these numbers? And is that $750 a month, give or take, all that the customer is going to see on their bill as far as an increase from Piedmont?
So the cost, let me unpack that question. There's a couple elements to it. With respect to the billed electricity cost, that was my direct testimony, pre-filed direct testimony in this proceeding sought clarification from the commission that Piedmont could recover those electric costs for bills from a local electric utility provider for costs associated with Piedmont's operation of its energy reliability centers. I sought the commission's clarification that we could recover that through the gas cost recovery mechanism. Appendix A. The gas cost recovery mechanism is described in Appendix A of the company service regulations. And so that in the stipulation, the parties have agreed that it is appropriate to recover those costs there. Those costs have not been present. The energy reliability centers, the two, in this case, went into service in July. So Piedmont has not the recovery of any prospective electric service costs at those stations has not become part of rates proposed in this case. And that would be addressed in future cost of gas proceedings as company use.
So the cost for the energy for those centers is not in here, and if I'm hearing you correctly, it's probably not a big number either, is it?
It's not.
Yeah.
It's a relatively small. I mean, I hate to say that $1 million is relatively small. It's not for me and many.
Sure.
But in the grand scheme of what our cost of service is, and particularly the cost of gas, because our concept is to treat it as a cost of recovery, as a cost of gas, since we could have used alternatively natural gas powered reliability centers instead of electric as we are. But $1 million is a very small portion, for example, of the 87 million annual costs that I cited earlier as our fixed annual gas cost estimate.
Okay. And just another question following up on Commissioner McKissick and Commissioner Kimwright on this low-income customer assistance program. That's not been developed yet. The $32 I'm reading about is not a real number. going to be an additional filing for that, and it was asked because as I read it, initially Piedmont was not going to do that, right?
Piedmont hadn't proposed it. Public staff proposed it as part of their direct testimony in this proceeding. They had a calculation supporting their proposal of up to $32 bill credit per month in the winter season. So it is not a program that is existing and operating today. The stipulation is simply that we are agreeing to develop that program and with more details to come with the compliance filing.
As you develop that program, is Piedmont's position that this $1 million a year that Commissioner Kimwright referred to, could that be paid for by shareholders?
Yeah, that is what the $1 million is referring to. We're not collecting that or would never collect. We've agreed to fund it without recovery from our customers, so hence from shareholders.
Okay, thank you.
You're
That's all the
welcome.
questions I have, ma'am.
Ms. Powers, one last question for you, since we're talking about those the reliability centers. Why the decision to go electric there as opposed to gas?
That was an operational decision.
I'm asking you something outside of your
Yeah, I think it was,
expertise.
certainly public staff asked similar questions pursuant to their discovery in the proceeding, but ultimately that was informed to be the prudent decision type of configuration for the facility. Hate to do this to y'all, but Mr. Weisker would be better suited to answer that question.
Okay. All right. Well, I'll just leave it alone for now. All right. Let me see if there are questions on commissioners' questions.
No questions.
Okay. Anyone on this side of the room? Piedmont?
I have a few follow-up questions,
Okay.
Chair Mitchell. Thank you. And I think I'll go in reverse order. And I'm not suggesting this is the answer to Chair Mitchell's last question, Ms. Powers, but is your understanding, and maybe you don't have an understanding to answer this question, so if that's the case, then please so indicate, but is it your understanding that air permitting may be required for natural gas compression equipment installation?
Believe I have heard that, yes.
Okay. And is, to your knowledge, is there air permitting requirements associated with electric compression?
To my knowledge, there is none.
Okay, thanks. Commissioner Tucker asked you some questions about the customer assistance program. And I just want to clarify, is it your understanding under the terms of the stipulation that that program will be formalized in writing and submitted to this commission for approval before it goes into effect?
Correct.
Okay. Do you have a copy of the stipulation?
I do.
with me? Could I ask you to turn to Exhibit C, Schedule 4 of 4? And this is in reference to some of the questions that Commissioner Hughes posed to you about sort of the allocation of usage over the course of the year. And I think it indicated that it was seasonal.
Yes.
So that the $750 a month was maybe not, the way customers would actually experience it. And I'm not suggesting that this is in lieu of more granular information that he requested we provide when we submit the customer assistance program filing. But does this schedule provide any more granularity about the seasonality of usage for residential customers?
It does as a class, yes.
Okay, and could you explain how that's represented on this?
Yes, on Exhibit C, Schedule 404, Row 1 is the residential class, and it's showing is used as billing determinants in this proceeding, the pro forma number of customer bills. So you divide that and that $8 million by 12 to know our customer count utilized for residential. It also shows for the class residential, the winter usage in decatherms and the summer usage in decatherms, yielding annual usage of approximately 39.7 million decatherms per year.
So this doesn't get us to the monthly analysis that Commissioner Hughes asked about, but it does get us to a sort of seasonal analysis, right?
It does. It shows that for the residential class of customers, 31 million of the annual 39 million is incurred in the winter season.
And that's a 5-month period from November to March, correct?
Correct.
Okay. Thanks. That's all the questions I have on that. And one last question. The annual residential usage of, I think you said 537 therms for an average residential customers was discussed in response to some questions from Chair Mitchell and also Commissioner Hughes. And it struck me when you said that you and I have been doing this for a number of years for the company. And how does that level of usage compare to, say, 10 years ago or five years ago for that average residential customer?
It has declined over time.
So, can you give us an order of magnitude?
Yeah.
And I don't know if you remember, I'm recalling some testimony in some previous rate cases about what average residential customer usage was. And
We've had a declining trend. When I look at our 2008 rate case,
Mhm.
normalized annual residential customer usage was around, I'll just refer to decatherms here, 58 decatherms. The 537 is roughly, with the decimal place, I'm going to round up, 54 decatherms. So it has declined.
Mhm.
And that's the annual usage. You can also look at it by heat sensitive versus baseload usage. The baseload usage has notably declined since that time as well.
Yeah. Do you have any opinions about why that might be occurring?
There are a variety. You think about it, there's more efficient equipment is one contributing factor. As you have equipment turnover, the availability of new equipment operates more efficiently, so there would be less usage of gas. And then changes in what equipment, there's choices. Customers do not have to use natural gas for their, in this part of the country for their energy needs. So equipment being changed to alternative types of equipment, such as for heating, space heating and water heating, that is another impact here that drives customer usage changes.
All right. Thank you. That's all the questions we have, Chair Mitchell.
All right, with that, Ms. Powers, your time with us has come to an end. We appreciate your being here and your providing responses to our questions. You may step down and be excused. And
Yeah.
yes, let me. I will get to that as soon as we dispense with Ms. Powers' testimony and evidence.
Yeah, Chair Mitchell, Piedmont would move that Ms. Powers' pre-filed exhibits be entered into the record as marked and as identified.
All right. Having heard no objection to the motion, the exhibits to Ms. Powers' testimony, the direct testimony and the settlement testimony will be received into evidence. All right. With that, we will take a 5-minute break. Let's go off the records. We will be back on around 12 o'clock. Please. All right,
Thank you,
Piedmont,
Chair.
you may call your next witness.
Thank you, Chair Mitchell. Piedmont calls witness Brad Evans to the stand.
All right, good afternoon, Mr. Evans. If you would, raise your right hand, left hand on the Bible. Do you swear the testimony you're about to give should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Mr. Evans, would you please state your full name and business address for the record?
My name is William Bradford Evans, and my business address is 525 South Tryon Street in Charlotte, North Carolina, 28202.
And by whom are you employed and in what capacity?
I'm employed by Piedmont Natural Gas, and I am a manager of rates and regulatory strategy.
And can you briefly describe your role and responsibilities at Piedmont for the commission?
Yes, I have various roles and responsibilities, including the development and execution of rate requests.
Thank you. And are you the same Brad Evans that caused to be pre-filed on April 1st, 2024 in this docket, direct testimony consisting of 31 pages and 10 exhibits?
Yes.
And did you also cause to be pre-filed on July 12th, 2024 in this docket, supplemental direct testimony consisting of 2 pages and 3 exhibits?
Yes.
Did you also cause to be pre-filed on July 29th, 2024 in this docket, second supplemental direct testimony consisting of 19 pages and 10 exhibits?
Yes.
And Mr. Evans, did you also cause to be pre-filed in this docket on August 28th, 2024, rebuttal testimony consisting of 10 pages?
Yes.
And finally, did you also cause to be pre-filed on August 29th, 2024 in this docket, third supplemental direct testimony consisting of 4 pages and 7 exhibits?
Yes.
And were all of the pre-filed testimonies that I just referenced prepared by you or at your direction?
Yes.
And do you have any changes to your pre-filed testimonies at this time?
No.
And if I were to ask you the same questions today that appear in your pre-filed testimonies, would your answers be the same?
Yes.
And your pre-filed testimonies did not include any confidential information, correct?
Correct.
And did you also cause to be pre-filed a summary of your direct, your supplemental direct, your second supplemental direct, your third supplemental direct, and rebuttal testimonies for this commission?
Yes.
All right, thank you, Mr. Evans. Chair Mitchell, at this time, I would move that Mr. Evans' direct testimony, his supplemental direct testimony, his second supplemental direct testimony, third supplemental direct testimony, and rebuttal testimony be entered into the record as if given orally from the stand, as well as the summary of his testimonies, and that his exhibits be identified as marked as when they were pre-filed and entered into the record at the appropriate time.
All right. The direct testimony of Piedmont witness Evans filed in the docket on April 1st, 2024, consisting of 31 pages and 10 exhibits will be copied into the record as if given orally from the stand. The 10 exhibits will be marked for identification as they were when pre-filed. The supplemental testimony filed on July 12th, 2024, consisting of 2 pages and 3 exhibits will be copied into the record as if given orally from the stand. The exhibits to that testimony will be marked for identification as they were when pre-filed. The second supplemental testimony filed in the docket on July 29th, 2024, consisting of 19 pages and 10 exhibits, will be copied into the record as if given orally from the stand, and the exhibits will be marked for identification as they were when pre-filed. The third supplemental testimony filed on August 29th, 2024, consisting of 4 pages and 7 exhibits will be copied into the record as if given orally from the stand, and the 7 exhibits will be marked for identification as they were when they were pre-filed. And the rebuttal testimony of witness Evans, consisting of 10 pages, filed in the docket on August 28th, 2024, will be copied into the record as if given orally from the stand. Summary of the testimonies will be copied into the record as if given orally from the stand as well.
Thank you, Chair Mitchell. Mr. Evans is now available for questions from the commission on his pre-filed direct and rebuttal testimony.
All right, Mr. Evans, good afternoon. Just a few questions for you. You've been in the hearing room this morning since Piedmont witnesses Weisker and Powers have been on the stand. Is that the case?
That's correct.
Okay. Did you hear my questions to both of those witnesses?
Yes, I did.
Okay. Did you hear their responses to those questions?
Yes, I did.
Okay. Is there anything that you need to provide in response to my questions that either clarifies or elucidates the answers that they gave me in light of the fact that I asked them questions that perhaps are in your subject matter expertise?
Not at this time, other than I believe there was something Ms. Powers referred to me.
Okay. Would you answer that question, please?
Could you please ask me the question again, please?
If I remember it. Okay, well, let me see here. I asked Ms. Powers a lot of questions about a number of questions about, the deferrals, the agreements that the parties came to related to the deferrals set forth in the settlement agreement. And, just, would you confirm Ms. Powers' testimony that, for the costs for the environmental activities and, costs associated with the PIMT and PIMD, expenses incurred through July or up to July 1, 2024. There have been agreements in the settlement regarding the amortization of those costs. The unamortized balance remains in rate base. Is that the case?
That is correct.
Okay. The Customer Connect, the total amount to be deferred associated with Piedmont's Customer Connect. Let me find the settlement provision. Customer Connect is 15,885. Is that correct?
That's correct.
Okay. And that total amount will be recovered, will amortized over a 6-year period, unamortized balance to remain in rate base. Is that correct?
That is correct.
Okay.
That is correct, less 1 year's worth of amortization. And that's a common practice in the way in which those reg assets are handled in the rate base component.
Okay. Okay. All right, got it. The character of the character of the expenditures for the Customer Connect project, do you know, are those expenses or?
Are you referring to the amounts that have been deferred thus far?
Yes.
Yeah, those are the deferred implementation costs of the system.
And do those costs include both expenses and capital investments? Or are they primarily expense?
Those are specifically expenses. The capital would be part of our overall plan service.
Okay. Okay. And to the extent that there is a discrepancy in the papers filed by the company in this proceeding, regarding the total amount to be recovered associated with the Customer Connect project. I asked Ms. Powers about that. In the most recent update, the total amount is indicated at 13 in the settlement agreement, which came after the last update. We see 15,885. Can you help us understand the discrepancy?
I'm not sure where the 13 million is per se. The 15 million is the amount that will be deferred.
Okay.
The 13 million could be the amount that's going into rate base. And so again, what I referred to previously, the amount going into rate base would be that total deferred amount less 1 year's worth of amortization.
Okay. All right. Anything that you need to add to Ms. Powers' explanation of unitization?
No, I do not.
Okay. Okay. All right, let me see if there are questions from commissioners for the witness. All right, Mr. Evans. Well, let me see if there are questions on commissioners' questions.
No questions.
Okay. Anything? Okay.
No questions.
Okay. All right, Mr. Evans, with that, your time has come to an end here. We appreciate your being with us, and you may step down.
Thank you very much.
Thank you. And Mr. Franklin.
Thank you, Chair Mitchell. With that, I move that Mr. Evans' exhibits be entered into the record at this time.
All right, having heard no objection to that motion, the exhibits that came in with pre-filed testimony will be admitted into the record.
Thank you, Chair Mitchell. Piedmont now calls witness Callie Cousins to the stand.
All right, good afternoon, Ms. Cousins.
Good afternoon.
If you would, please left hand on the Bible, raise your right hand. You swear the testimony you're about to give should be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you, Chair Mitchell. Ms. Cousins, would you please state your full name and business address for the record?
My name is Callie Cousins. My address is 525 South Tryon Street, Charlotte, North Carolina, 28202.
All right. Why don't you pull that mic a little bit closer? There we go. Thank you. And by whom are you employed and in what capacity?
I'm employed by Piedmont Natural Gas as the Director of Gas Rates and Regulatory Strategy.
And are you the same Callie Cousins that caused to be pre-filed on April 1st, 2024 in this docket, direct testimony consisting of 26 pages and 12 exhibits?
Yes.
And Ms. Cousins, did you also cause to be pre-filed on July 12th, 2024 in this docket, supplemental direct testimony consisting of 3 pages and 7 exhibits?
Yes.
Did you also cause to be pre-filed on July 29th, 2024 in this docket, second supplemental direct testimony consisting of 5 pages and 10 exhibits?
Yes.
And did you also cause to be pre-filed on August 28th, 2024 in this docket, rebuttal testimony consisting of 7 pages?
Yes.
And finally, did you also cause to be pre-filed on August 29th in this docket, August 29th, 2024, in this docket, third supplemental direct testimony consisting of 4 pages and 7 exhibits?
Yes.
And were all of these pre-filed testimonies that I just referenced prepared by you or at your direction?
Yes, they were.
And do you have any changes to your pre-filed testimonies at this time?
No.
And if I were to ask you the same questions today that appear in your pre-filed testimonies, would your answers be the same?
Yes.
And just to be clear, your pre-filed testimonies did not include any confidential information. Is that correct?
Correct.
And did you also cause to be pre-filed a summary of your direct, supplemental direct, second supplemental direct, third supplemental direct, and rebuttal testimonies for this commission?
Yes.
All right, thank you. Ms. Cousins. Chair Mitchell, at this time, I would move that Ms. Cousins' direct testimony, her supplemental direct testimony, her second supplemental direct testimony, third supplemental direct testimony, and rebuttal testimony be entered into the record as if given orally from the stand, as well as the summary of her testimonies, and that her exhibits be identified as marked as when they were pre-filed and entered into the record at the appropriate time.
All right, having heard no objection to the motion, the direct testimony of witness Cousins filed in the docket on April 1st, 2024, consisting of 26 pages, will be copied into the record as if given orally from the stand. The 12 exhibits to that testimony will be marked for identification as they were when pre-filed. The supplemental testimony filed by the witness on July 12th, 2024, consisting of 3 pages, will be copied into the record as if given orally from the stand, and the 7 exhibits to that testimony will be marked as they were when pre-filed. The second supplemental testimony filed in the docket on July 29th, 2024, consisting of 5 pages, will be copied into the record as if given orally from the stand. The 9 exhibits to that testimony will be marked for identification as they were when pre-filed. The third supplemental testimony filed in the docket on August 29th, 2024, consisting of 4 pages, will be copied into the record as if given orally from the stand. 10 exhibits to that testimony will be marked as they were when pre-filed. And the rebuttal testimony filed in the docket on August 28th, 2024, consisting of 7 pages, will be copied into the record as if given orally from the stand. The summary of those testimonies will also be copied into the record as if given orally from the stand.
Okay. Thank you, Chair Mitchell. We're just double checking on those exhibit counts to make sure that we've got them correct on our end. Specifically, we're checking the third supplemental direct testimony. I have it here as 7 exhibits, but we're checking to make sure that that's correct. And then also the second supplemental direct testimony, I believe I have that here as 10 exhibits, but we're also making sure that that's correct. Is it 10? Okay. So just for the record, making sure that the July 29th filing, second supplemental direct testimony is 10 exhibits, and that the third supplemental direct testimony is 4 pages and 7 exhibits. that correct? Right, good. Glad we got that cleared up. So thank you for that. So the August 29th, 2024, third supplemental direct testimony, you have that correct. There's 4 pages and 10 exhibits. So thank you for that, Chair Mitchell.
Okay. All right.
All right, Chair Mitchell, Ms. Cousins is now available for questions from the commission on her pre-filed direct and rebuttal testimonies.
All right. Good afternoon, Ms. Cousins. You've been in the hearing room this morning during the questions directed at Ms. Powers and Mr. Weisker. Did you hear, is that a yes?
Yes,
Okay.
I did.
And did you hear the responses they gave to those questions?
Yes, I
Okay.
did hear.
Do you have anything to add to those responses, either to clarify or elucidate the responses they gave?
There was one item related to the impact to residential annual customer bills. The question was regarding what was the impact without the effect of the rider. So we spoke about the impact for year one, but the question was without the riders, year two, what would the impact be? And so the information that I have for you is, well, what we presented as year one was $90 per year for a residential customer. That's the increase. And it was $750 per month. Without the riders, the amount is $99 per year or $825 per month.
Okay. Thank you, Ms. Cousins. Ms. Cousins, isn't it the case that the company serves certain customers pursuant to contracts, special contracts it may have with those customers?
Yes, that's correct.
And can you help us understand what types of customers the company might enter into such a contract with?
Yeah, so there are primarily large volume customers. Some of them are power generation customers, other customers that are seeking service from Piedmont, whereas the recovery from them based off of our tariff rates would not be feasible for us to serve them. So special contracts are developed to be able to get the appropriate recovery to serve those customers.
Okay, so the revenue requirement that has been agreed to in this case is set forth in the settlement agreement. My understanding, and please correct me if my understanding is wrong, is that the revenue requirement reflects costs to serve all customers. And then for those customers with which Piedmont has entered into these special contracts, only incremental costs associated with those customers' requirements of Piedmont are collected pursuant to those contracts. Is that right?
So the revenue requirement computation does include the revenues and expenses associated with those special contracts.
Okay, so all,
Mhm.
okay.
That's
Well,
correct.
thank you for clarifying that. Okay. And do you know off the top of your head how many such contracts are effective right now?
Oh,
If the answer is no, that's fine. I'm just,
no, I don't want to guess on that.
okay. Who manages those contracts within Piedmont?
So we have a group, our major account services group that evaluates the service that the customer is seeking and assesses what the company needs to recover in order to provide that service.
Okay. Okay. Let's see. just go through my notes one more time. Ms. Cousins, to the extent that you are capable of answering, please do. If not, I will hold the question. In the explanation of, I think it's demand costs, but also it's called something different in the settlement agreement. Fixed cost. Ms. Powers referred us to Exhibit G to the settlement agreement. And they're sort of just, I'm paraphrasing, but that exhibit shows certain transportation contracts and storage contracts that Piedmont has entered into. Or is my understanding correct?
Yes, those are demand fixed gas costs.
Okay. Certain of those contracts that Piedmont has entered into for storage, for example, Ms. Powers explains are FERC jurisdictional contracts, are either involve rates established by the FERC or contracts that are jurisdictional to the FERC. Is that correct?
Yes.
Okay. Are you aware, so to the extent that are you aware of whether any of those contracts involve the Transco as a counterparty? Transcontinental?
Yes.
Okay, so let me ask the question differently. Do any of those contracts involve Transco as a counterparty?
Yes.
Okay. And are you aware that Transco has initiated a rate case before the Federal Energy Regulatory Commission?
I am not aware.
Okay. To the extent that Transco had initiated a rate case, would you expect Piedmont to be participating in that rate case to get the best deal for its customers?
Yes.
Okay. To the extent that Transco achieves in that rate case an increase to its rates, would those costs flow on to Piedmont's customers under any of these contracts to the extent that you know?
They would if they pertain to the Transco contracts on this sheet.
Okay, so therefore, the potential exists that Piedmont's customers could be paying more as a result of the outcome of that Piedmont rate, that Transco rate case.
That's correct.
Okay. All right. All right, let me see if there are other questions for you, Ms. Cousins, from commissioners. Okay, questions on commissioners' questions? We'll go over here first.
No question.
Okay. Piedmont?
No questions.
Okay. All right, Ms. Cousins, that was short and sweet. We appreciate your being here with us this morning. You may step down and be excused.
Thank you.
Chair Mitchell, before I move those exhibits into the record, I put on my super sleuth hat and I figured out what's going on here with those exhibits to her August 29th third supplemental testimony. There are actually just 7 exhibits. We numbered them in a way where her supplementals went consecutively 1, 2, 3, 4, but then they jumped to non-consecutive numbers. After 5, they jumped to 9 and 10. So I think that's where the confusion lied. So for the record, just to make sure we're correct, she does have 7 exhibits to her third supplemental.
But they were marked for identification as 1 through 10 when they were pre-filed. Is that right?
When they were pre-filed, they were marked for identification as.
I think what happened is that we maintained the same numbering convention so that they corresponded to the original filed exhibits. So, but several were not required to be refiled.
Right.
Okay.
That's correct.
All right. Well, let's just, for the record, the exhibits to this, that's third supplemental testimony will be marked as they were when pre-filed and admitted into the record.
Correct.
Okay. All right. And as to the second supplemental testimony, is the record clear on that?
The record's clear on that.
Okay. Okay. All right. And then I'll take a motion.
I'm doing it right now. Chair Mitchell, go ahead and move that Ms. Cousins' exhibits be entered into the record at this time.
All right. Having heard no objection, we will, I'll allow that motion.
Thank you.
Chair Mitchell, that concludes the presentation of Piedmont's case.
All right. Thank you, Mr. Jeffries. And I will look to this side of the room now. Ms. Yost, let's start with your witnesses that have been excused and let's get their testimony into the record.
Thank you. I would move that the pre-filed testimony of the following witnesses be copied into the record as if given orally from the stand, and that their exhibits be identified as marked when filed and entered into evidence. First, the testimony of Roxy McCullough, consisting of 15 pages, and McCullough Exhibits 1 through 3, filed on August 13th, 2024. Second, the joint testimony of Blaise C. Michna and Andrew R.S. Puglisi, consisting of 22 pages and appendices A and B, filed on August 13th, 2024. Third, the testimony of Gregory J. Rieger, consisting of 17 pages, Appendix A, and Rieger Exhibits 1 through 4. There are both public and confidential versions of that testimony, and they were filed on August 13th, 2024. Fourth, the testimony of Christopher C. Walters, consisting of 102 pages, Appendix A, and Exhibits CCW-1 through CCW-15, filed on August 13th, 2024. And then finally, the testimony of Jordan C. Nader. And first, I have a motion regarding that. On September 16th, 2024, the public staff filed a motion for leave to file the revised testimony and exhibit of witness Jordan A. Nader. The commission issued an order accepting that revised testimony on September 17th, 2024. Thereafter, it came to our attention that Nader Exhibit 1 was inadvertently omitted from the revised testimony filed on the 16th of September. And on September 17th, the public staff refiled the revised testimony with the missing exhibit. And I would move that the version of Mr. Nader's revised testimony filed on September 17th, including the exhibit, be accepted.
Okay, I'll allow that motion. So the testimony of public staff witnesses McCullough, Michna, and Puglisi, is it Rieger? Rieger. Okay, and Walters will be copied into the record as an orally stand, and the exhibits to those testimonies will be marked for identification as they were when pre-filed and also accepted into evidence. With respect to witness Nader, the testimony filed on refiled on September 17th, 2024, consisting of 31 pages.
That is...
One appendix and one exhibit.
Yes.
Will be copied into the record as if given orally from the stand, and that exhibit will be marked for identification as it were when pre-filed.
Thank you. And at this time, the public staff would call Michelle M. Boswell to the stand.
Did I say? Did admit what? Okay, and the exhibit to Mr. Nader's testimony will be admitted to the record. All right. Good afternoon, Ms. Boswell. All right, if you would, left hand on the Bible, raise your right hand. You swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Good afternoon, Ms. Boswell. Could you please state your name, business address, and present position for the record?
My name is Michelle Boswell. I'm the Director of Accounting for the Public Staff. My address is 430 North Salisbury Street, Raleigh, North Carolina.
On August 13th, 2024, did you, along with Public Staff Accountant Quay Fenton Son, prepare and cause to be filed in this docket joint testimony consisting of 35 pages, appendices A and B, and one exhibit?
I did.
And did that exhibit contain confidential information?
It did.
On August 13th, 2024, did you, along with Public Staff Witness Gregory J. Rieger, prepare and cause to be filed in this docket joint testimony consisting of 19 pages, appendices A and B, and 9 exhibits?
I did.
And on September 13th, 2024, did you, along with Public Staff Witnesses Quay Fenton Son and Jordan A. Nader, cause to be filed in this docket joint supplemental and settlement testimony consisting of 7 pages and 1 exhibit?
I did.
Do you have any corrections to any of those testimonies?
I do not.
If you were asked the same questions today, would your answers be the same?
They would.
Chair Mitchell, I would move that the joint testimony of Quay Fenton Son and Michelle Boswell, the joint testimony of Gregory J. Rieger and Michelle Boswell, and the joint supplemental and settlement testimony of Quay Fenton Son, Michelle Boswell, and Jordan Nader, and the accompanying exhibit be entered into the record, and that their accompanying exhibits be identified as marked when filed.
All right, I'll allow that motion. The testimony will be copied into the record as if delivered orally from the stand, and the exhibits to the testimony will be marked as they were marked for identification as they were when they were pre-filed. And I'll also go ahead and admit those into the record. Ms. Yost, did the public staff provide summaries of their witnesses' testimonies?
Did not.
Okay. All right.
Ms. Boswell is available for questions from the commission.
Okay, Ms. Boswell, this will be relatively quick and hopefully painless. You've been in the hearing room this morning while the commission has directed questions to Piedmont witnesses. Is that correct?
Yes, ma'am.
Okay, and did you hear those responses given by Piedmont witnesses?
Yes, ma'am.
Is there anything that well, let me say this, with respect to discussion of the settlement agreement and provisions of the settlement agreement, is there anything that you would like to say in response to what you heard from Piedmont or in response to the questions from commissioners?
No, ma'am.
Okay. And you are in agreement with Piedmont that in the case of the unitization terms of the settlement, the commission can expect to see a proposal from the public staff and the company in the next IMR proceeding?
For the IMR portion, yes.
Okay. Thank you for clarifying. And then on the customer assistance program, we will see a subsequent filing from the company and the public staff on that issue as well.
Yes.
Okay. The PIMT and the PIMD deferrals, we've already, at least my understanding based on testimony given today and the settlement agreement is, my read of the settlement agreement is that those deferrals, the unamortized portion of those, the deferred amounts will accrue a return. Is that correct?
That is correct.
Okay, and is that, but the character of the amounts deferred there are expenses? Is that is that the public staff's understanding?
They were O&M expenses originally, yes.
Okay. And does the public staff typically agree that when amounts that are expenses are deferred, they're entitled to a return?
It's on a case-by-case basis.
Okay. All right. And your response to that is the public staff comes to that conclusion on a case-by-case basis?
Yes, ma'am.
Okay. Okay. Ms. Boswell, during the last rate case proceeding, this commission asked for a late file exhibit from the public staff. And docket numbers are associated with the proceedings G9 sub 722, 781, and 786. It was a confidential late filed exhibit that the public staff provided, and it's identified as public staff confidential late filed exhibit number 2, and it was made in the docket on September 28th, 2021. I'm not sure if you sponsored this docket or prepared the spreadsheets that are sponsored this exhibit or prepared the spreadsheets that were included. But do you recall this exhibit?
I did not sponsor them. Yes, I do recall the exhibit.
Okay, well, one of the worksheets in the exhibit identifies, and it's confidential, so we're not going to get into it, but it identifies the electric generation contracts and the special contracts that were then in effect between the company and its customers. I would ask that the public staff update that specific worksheet, that one worksheet, and provide that to the commission as a late filed exhibit in this docket.
We would be happy to do so.
Okay. And certainly if you need to work with Piedmont to get that done, please do. I hope that's not, I'm not asking anything controversial there. It's just updated information. Okay. All right, let me see if there are questions from other commissioners. Let's see, Commissioner Tucker, Commissioner Kimwright, anybody down here? Okay.
And Ms. Boswell, following up on Ms. Powers' testimony about the unitization, I think that she stated that Piedmont had agreed to the unitization standard at the request of public staff, and that the public staff could better explain why they thought it was important and what the practical significance of that is. Did you hear her testimony about that? Would you like to provide the public staff's perspective of the standard and why it's important?
Sure. And we laid out most of our thoughts in our initial testimony. However, unitization's been a longstanding issue with many utilities across North Carolina. And the underlying issue is when the plant is unitized, it goes into service and the company is allowed to earn a return on that because it is used and useful at that point in time. However, it is based off of a generalized depreciation, which causes issues down the road. The longer it takes to unitize that, the longer it sits in that generalized depreciation, which theoretically is corrected, for lack of a better term, in future depreciation studies as you weigh how much you've collected versus how much you should have collected and what the assets are remaining in those accounts. We prefer to minimize that to the largest degree possible. It also just quite frankly just represents bad management. If you can go forth with a project and get the project to completion, you can then see it to make for sure that it is completely closed into account 101 in a timely fashion.
Thank you.
Okay, Ms. Boswell, just one follow-up there, and I'll, Commissioner Tucker, I apologize, I want to follow up with her on this topic. So I just want to understand, so when the plant goes into service, the company it begins earning its return on that plant, and also recovering for it through the depreciation expense. And what I hear you saying is the depreciation expense is a generic depreciation expense, which might change based on as a result of the unitization process, or is it a timing issue? I guess I'm trying to understand the impact to customers.
Sure, and it really depends on what plant and what utility you're talking about. And in general terms, they use a general depreciation rate, which is the driver of what gave rise to the asset in general. And then once you're finally unitized, the plant goes from 106 to 101 and is then put into all of the specific FERC accounts for which it should otherwise be assigned to. And at that point in time, it's then given that specific depreciation for those costs to that FERC account.
Okay, so the public staff's wants. Is it the public staff's position that the amount of time to get to those specific FERC accounts should be kept to a minimum?
Yes.
because then is that, and is that because it impacts the amount the customers are actually paying?
It's for a variety of reasons. Number one, it's hard to audit when it's in 106 and when AFUDC should have shut off versus when depreciation begins and when they're doing it after the fact and they closed it, but they're still unitizing after the fact. It creates chaos in the audit. And then it can create intergenerational issues because while it's corrected or trued up within depreciation studies going forward, it's those that are going forward, not necessarily who at the time that it gave rise to those assets on a very generic. And I misspoke, it's not FERC accounts, it is plant accounts that roll up into the FERC account. My apology.
All right, thank you for that clarification. All right, Commissioner Tucker.
Thank you, Madam Chair. Thank you, Ms. Boswell, for being here and answering our questions. Mine should be short and sweet as well. When I looked at the matrix I had received that had contested issues, which are no longer being contested in the settlement, it stated that Piedmont was not proposing additional programs for low-income customers at this time. Then in the next column, it says that you suggest a 32 winter month bill credit. Is that correct?
A $32 a month, yes, bill
Okay.
credit.
Help me understand what the genesis is for that. Is that because other utilities do that? Why wouldn't it be $42? Because I believe if I remember correctly, that's Duke's income assistance.
It is, and the calculation of the $32 is very similar to the calculation that for Duke's $42. And so it's taking the winter bill, the average winter bill, and taking approximately 30% of it, and then just basically rounding up to the closest dollar.
All right. Since Piedmont was not proposing that, why did you propose it?
Because we think it's in the best interest of ratepayers.
Okay, so let me ask you this then. In the discussions, and I know it's preliminary and you're trying to work it out, but did the public staff propose that the shareholders pay for it?
Yes.
And did Piedmont agree to that?
So in the stipulation, the $1 million for each of the 3 years is going to be funded by shareholders.
Okay. I mean, I look at these and I understand these, and having worked in Charlotte with some of these situations before, Piedmont has utilized referrals to DSS through temporary assistance to needy families, crisis assistance ministry. There are churches, there are all kinds of folks that help pay these bills with benevolent committees and those kind of things. Help me understand why that's in the best interest of ratepayers, because what I see is a program starting and then it goes from shareholders or pushback from shareholders, or the number grows as the needs grow. And then the next thing you know, we've got instead of a needy assistance program, we have a mandated donation from ratepayers. So those who are able to afford it and those who cannot. Why are we going this way if Piedmont was not proposing it?
So the public staff, in our testimony, we outlined the reasons behind. We believe it will have a material impact, especially to the uncollectibles going forward, which affects all ratepayers across the board, that uncollectibles rate, which is factored into the revenue requirement that's before you in every case. And so helping to minimize that and reduce that to the largest degree possible. The other programs that you listed will still exist, but they commonly run out of money and commonly run out of money fairly early on. And it's not enough to pay all of the bills of the individuals who honestly need the most help.
Okay, but if I understood, maybe Ms. Powers or somewhere I read, the uncollectibles for Piedmont are not, they're pretty level year to year, and now we're assisting something that's been pretty level. I'm just trying to get a feel for where it came from.
Sure. So I don't know that they have been necessarily level. In this stipulation, we have proposed a 5-year normalization to represent ongoing. to account for ebbs and flows, and the parties have all agreed to that within the confines of this case.
Okay,
But with programs that help those low-income individuals to pay their bills on time, that should then reduce those uncollectibles, whether we use a year over year or a multi-year average going forward.
okay, so you're saying, if I understand, and you correct me if I'm wrong, and I certainly can be, it's just you're covering one pot of money with another pot of money. Would that be a fair analysis? Meaning, you see where I'm going with this? I mean, you're saying that over a 5-year period, that, Piedmont would be paying that to help these customers out, therefore lowering uncollectibles. But your main drive is to make sure people have heat. But, this is going down and this is going up, and it's the same pot of money, really. Is it not?
Well, it's not, because the
same impact.
uncollectibles aren't funded by shareholders, they're funded by ratepayers.
Okay,
And so the $1 million for the 3 years are funded by shareholders.
okay, so public staff's position very strongly is that it should be paid for by shareholders, and Piedmont's position, if I'm reading here correctly, did not agree with that initially.
Piedmont did not propose a program.
Okay,
The public staff did propose a program initially, and the settlement creates a compromise where there will be a program instituted for which Piedmont shareholders will fund the first $1 million for those first 3 years.
okay, and then after the 3 years, who would do that? Then it'd be one or the other?
In all likelihood, they will be back in for a rate case, and we will be back here discussing it then.
Okay, thank you, ma'am, so much for those comments. That's all I have, Madam Chair.
Go ahead, Commissioner McKissick.
Ms. Boswell, do you recall what the uncollectibles currently are for Piedmont?
The 5-year average or the year over year?
Well, let's look at the 5-year average, if that's easier for you to obtain, or if you do have it year over year, that's whatever is easiest for you to refer back to and present as part of this record.
And that is actually in our settlement exhibits. In Schedule 3-1, and let me get to the appropriate subletter.
Okay, thank you.
So it is listed in Supplemental and Settlement Exhibit 1, Schedule 3-1S,
Okay,
line 9, and it is listed as 0.4867%, which represents the stipulated agreement to utilize that 5-year average.
that 5-year average, and that's what you're referring to in terms of the pilot that will be forthcoming. That will be the standard that you look at with the pilot that's going to be forthcoming from Piedmont in the next 6 months. Is that?
So we would be looking at the 5-year.
Yes.
And taking the new 5-year over that term, year over year as well. Yes.
Oh, got it. And public staff at this point in time is looking at, I think as you articulated, the 30%
Ish, yes.
ish. And at this point in time, are you looking at it as being perhaps a flat bill credit or based upon volume that might be used by customers?
We are looking at a flat bill credit.
A flat bill credit. Okay. But at this point in time, the parameters of that bill credit for this customer assistance program are undefined. It's going to be what you're going to be working on moving forward.
Correct.
Well, I look forward to seeing what that looks like. I commend the public staff for making the recommendation, and I commend Piedmont for its agreement to institute such a program as a pilot, and look forward to having substantial positive impact upon those that are households in our state that can least afford to pay for utilities, and in this particular case, gas, and how they might be adversely impacted by the increase that's been proposed and stipulated to in this particular case. Thank you.
It's possible, just one question. what is the uncollectibles? What is the uncollectibles that appears in the revenue requirement in this case?
The percentage that is on that 3-1S. So the 0.4,
4867?
yes.
Okay. So translate that into where can I see that translated into dollars as a component of the revenue requirement?
So we made the adjustment and agreed to upon settlement
Mhm.
that's reflected on line 13 that then rolls into Schedule 1. And then the uncollectibles also plays a role in the retention factor for the gross up that's reflected in all adjustments.
Okay, so the 6 million there, that's not included in the revenue requirement. But you use that uncollectibles percentage elsewhere to get to elsewhere in computation of the revenue requirement?
So the 6,075,169
Mhm.
that's referenced
Mhm.
is in the calculation of the total because the company included the 6.974 in its cost of service in calculating the revenue requirement. So the schedule, the 898 that's listed on line 13 reduces that 6.97 that the company reflected in its cost of service in calculating the revenue requirement.
Okay, and then I think I'm following you. But then when I look at settlement exhibit PKP1, I see an adjust uncollectibles.
Mhm.
Do you have that schedule in front of you or exhibit in front of you?
Yes.
Okay, so help me understand that number.
And hold on. So line 36,
Mm-hmm.
the 904,894
Yes.
comes from that 3-1S, which then leads into your 3-1 in totality, the large 3-1 schedule and supplemental and settlement exhibit 1.
Okay.
And I can get you to a column. It is column P on page 2, that last column in page 2 on 3-1. And so you will see on line 8, there's the 898, 959, that's from the 3-1S is the adjustment. And then you have to calculate in the state and federal income
Got it.
taxes associated with it to calculate down there on
Got it.
line 17, the 904 that appears on Schedule 1.
Okay. All right. I appreciate it. Thank you for walking me through that. Okay. Any additional questions for Ms. Boswell? Questions on Ms. Boswell on commissioners' questions?
No questions. Thank you.
No questions.
All right, Ms. Boswell, thank you very much. We appreciate it. You may step down and you are excused.
There is one matter. I failed to move one of our sets of pre-filed direct testimony into the record. May I do that at this point?
Let's do this. I believe, well, I've already admitted into evidence Ms. Boswell's exhibits, so yes, you may do that.
All right. I would move that the pre-filed direct testimony of Andrew R.S. Puglisi and Neha R. Patel, consisting of 13 pages, appendices A and B, be copied into the record as if given orally from the stand, and that their 2 exhibits be identified as marked when filed and entered into evidence.
All right, there being no objection to that motion, I will allow it.
Thank you.
Okay. All right. Let's see. At this point, Mr. Trathan, would you like
Yeah.
to get your witness's testimony admitted?
Yes, absolutely. Thank you, Chair Mitchell. We had CUCA presented 2 witnesses, both of which were excused from the hearing by order of the chair dated September 16. Therefore, I would at this time move that the pre-filed direct testimony of Billy S. LeConte, consisting of 29 pages, which is inclusive of appendices A through C, plus 2 exhibits as pre-marked be entered into evidence as if orally presented from the stand.
All right, I haven't heard an objection to that motion, so I'll allow it. And the testimony of witness LeConte will be copied into the record as if given orally from the stand. The exhibits to that testimony will be marked for identification as they were when they were pre-filed, and they will be admitted into evidence.
Thank you, Chair Mitchell. I'd also move that the pre-filed direct testimony of Jonathan Lee, consisting of 26 pages inclusive of appendices A through C, plus 3 exhibits as pre-marked, be entered into evidence as if orally presented from the stand.
All right, the testimony of witness Lee shall be copied into the record as if given orally from the stand. The 3 exhibits to that testimony will be marked for identification as they were when they were pre-filed, and they will be admitted into evidence.
Thank you.
All right, we have come to the conclusion of the hearing. Let me check in with council to see if there are any additional matters we need to address before we adjourn.
Yeah, the only additional matter I'd like to address, Madam Chair, is I'd like to thank the intervening parties in this proceeding for the collaborative and cooperative way in which they pursued what was a long and intensive investigation into Piedmont's filing. And we'd also like to thank the commission for their time and attention to this matter.
Thank you, Mr. Jeffries. We too appreciate the work and efforts of the parties in this proceeding, and the getting through this case with, I don't think there was a discovery dispute that we had to resolve at least. So good work. And appreciate the quality of the presentation of evidence. Chios, did you have something?
I would just echo Mr. Jeffries' comments.
All right. All right. Well, as we typically do, we'll take post-hearing filings, whether it be brief or proposed order, as soon as you want, but no later than 30 days following the availability of the transcript. And with that, we will be adjourned. Thank you very much. We're off the record.
Thank you, Chair Mitchell.